I double dog dare you.
Ma'am, you can't sue the baby.
This case is horrible.
The promiscuous defecation kind of speaks for itself.
Hey everyone, if you are here today, welcome and thank you. This is part 3 of our 24 hours of 2024 court that we probably missed. This is something that we probably wanted to see but didn't realize was even there. A jury trial proceeded over by our beloved Judge Alexandra Manning from Fulton County, Georgia. She has told us all, stay out of Fulton County, but nobody seems to listen. And this guy was driving through and had a little fender bender while he was having a little drinky drink. Didn't go over too well. So, if you missed part 1 and part 2, you can see some of the judges that you missed. A couple from Washington State, Nevada, Kansas, Texas, beloved Judge Vann from Florida, Kentucky, Indiana, Wisconsin, Michigan, and Judge Jacobs from Dekalb. Links to part 1 and 2 are in the description, as well as the timestamps for what judge you want to see. We will continue on tomorrow with part 4, then part 5, before we start on our 2025 journey. Now, let's go to court.
I don't know what the real story is here, folks. I don't appreciate it.
But does it really matter?
If no good deed goes unpunished.
You're going to make me send you to jail.
And how long have you been with Georgia State Patrol?
Approximately 3 years.
And what are your current duties and responsibilities?
Enforcing traffic laws, criminal laws, working traffic accidents, fatalities, assisting other agencies when needed.
And are you post-certified?
I am.
Can you please explain to the jury what post-certified is?
I have my credits to, having no credits to, I went through the academy, took all the classes needed to carry a firearm and enforce the law.
And in your employment, have you had any type of training?
I have.
And what kind of training have you had? Let me ask this. What kind of training have you had that's relevant to this case?
Field sobriety training.
And in that field sobriety training, did you have to pass a test to get your certification?
I did.
And did you pass your test?
I did.
All right. Throughout your training, have you had the experience to detect the smell of alcohol?
I have.
And how often do you come across that?
Pretty often. Coming in contact with people every day. So.
And were you working on the night of May 29, 2022?
I was.
And were you in full uniform, including your badge?
I was.
And were you in a marked patrol vehicle?
I was.
Did you ever investigate a case involving the defendant, Mr. White?
I did.
And do you see him in the courtroom today?
Yes, I do. Yes, I do.
And could you please point him out and describe something he's wearing?
Feel free to stand if you need.
It's like a blue suit, bald head, black man.
And Judge, for the record, let the record reflect that the witnesses identify the defendant in the case.
All right, it will so reflect.
When did you first become involved with Mr. White's situation?
That morning of, it was May 29th.
Around what time?
5 o'clock, approximately around that time.
And how did you make it to the location?
I was working midnights and I got called to a traffic accident, 85 North. I think it came out like near 400, but it was on like Beaufort Highway area in between the middle of 400 and Beaufort.
And what county would that be considered?
Fulton County.
Okay. And when you arrived, or I guess, how did you hear about it?
I got called from my communication center to respond to an accident.
Are you aware of who reached out to the communication center?
Atlanta Police Department did.
Okay. And so when you arrived, what did you observe?
Put up on scene. I seen multiple lanes being blocked by Hero, Atlanta Police Department and Fire Department, and I seen several vehicles scattered over the roadway. I believe Mr. White was driving a Chrysler 300, and then there was a truck to the right, and then there was another vehicle.
And when you arrived, did you speak with anybody from APD?
Yes, I did. APD Officer Lane, when I got on scene, he briefed me on the situation about what happened and why I was called out.
And what did he tell you, if anything?
Accident had occurred. Driver, Joshua White, was the driver of the Chrysler in the middle of the roadway, and it was a mess out there.
And when you say a mess out there, can you describe the damage to the vehicles?
Disabling damage, I believe, on all three vehicles. They were towed away from the scene.
So you wouldn't classify it as would you classify it as a fender bender?
No, not the way those vehicles were messed up, no.
Now, did you ever speak with Mr. White?
I did.
Okay. And when you spoke with Mr. White, what, if anything, did he say?
After I spoke to Officer Lane, I approached myself to Mr. White, asked how he was doing. I said if he needed any medical assistance due to the severity of the scene. He said no. And then after that, I went into field sobriety.
Why'd you go into field sobriety evaluations?
I was notified that when APD officer pulled up, Mr. White was pouring alcohol from another cup onto the roadway.
And did you observe anything about Mr. White's person that led you to believe that a field sobriety evaluation was warranted?
When I spoke to him, a little bit swaying, and when I talked to him, strong odor of alcoholic beverage was emitting from his breath.
And was he away from the vehicle while you were speaking with him?
He was, I believe he was like right in front of his hood of his vehicle. So standing in front of outside.
Okay, and so would you say that the smell of alcohol you were smelling, was it coming from the vehicle or was it coming from him?
It was coming from him.
What are field sobriety evaluations?
Evaluations I go through to evaluations I go through to what am I trying to look for?
It's okay. We all have those moments.
Look for clues of impairment. I'm sorry.
And what are clues of impairment? What do you mean by that?
Intoxication of an individual. So when you say can you rephrase the question?
Well, let me ask you this. What are the 3 evaluations that you performed on Mr. White?
Before I started, I medically cleared him. And then the 3 parts can pertain to field sobriety is lack of smooth pursuit, distinct nystagmus at maximum deviation, and onset nystagmus prior to 45 degrees.
Okay, so I'm gonna back it up a little bit.
Okay.
So when you say medically cleared, why do you medically clear someone?
To see if they have nystagmus before I start the exam.
Okay. And so which examination are you speaking of now? So you gave me 3 things: distinct nystagmus, maximum deviation at 45 degrees, and onset of nystagmus. What evaluation are all of those under?
HGN,
Okay.
horizontal gait nystagmus.
Okay, so the first test that you performed was HGN.
Correct.
Consisted of those 3 things. So
Correct.
when you medically cleared him, what exactly did you see when you were performing that evaluation?
Involuntary jerking of the eyes, which would be nystagmus.
Okay, so that involuntary jerking of the eyes, what is that caused by?
Intoxication, alcohol.
Alcohol. So okay. So when you performed this evaluation, where did you have the defendant stand?
He was doing it I did in front of his car initially, then I brought him for a closer view in front of my camera. I brought him in front of my patrol car, and then I examined it.
Were you wearing a
Examine
body
him.
worn cam that evening?
I was. We have a mic. Yes, I was, along with my
And
dash cam footage.
showing defense counsel was previously marked as state's exhibit number 1. The dash cam. Yes, ma'am.
Okay.
Yes, ma'am. This state would like to approach the witness, please.
Okay.
Trooper Fernandez, can you please tell me what that is?
Exhibit number 1 has Joshua White's name and then has my name with initials.
Do you know what it contains?
I believe it's footage of my evaluation of Mr. White.
Excellent. The state would like to tender in the state's exhibit 1, the dash cam and mic pack of Trooper Fernandez.
No objection. All right, submitted.
All right, may we publish?
Yes.
Your Honor. So, Trooper Fernandez, I'm going to have you explain to the jury as we're watching each of the things you just told us.
Okay.
So I'm going to pause really quickly. Can you tell us whose car is where? Or I guess, can you tell us where Mr. White's vehicle is?
Mr. White's vehicle is right in front, right behind of all 3 of the people you see with the reflective vest on.
Okay, so if you wouldn't mind standing up and just pointing up.
Oh, I'm sorry.
Yeah, watch your head. Okay, awesome, thank you. So at this point, who are you speaking with?
Officer Lane of Atlanta Police Department.
So for the record, for a little bit of timeliness, I'm gonna move forward a little bit to 7:20. 7:16. Stopping at 8:10 for the record. Maybe. So stopping at 8:10 for the record. That's why, there we go. What was that conversation that you had with Mr. White there?
I medically cleared him to see if he was able to perform field sobriety evaluations.
Okay. So at this point, are we getting ready to begin the HGN?
Yes, we are.
Okay.
Is it possible they could be told to quiet down? It's just.
I thought it was
hard to
just me
hear.
hearing it with my
No.
hearing aids on.
Get that frequently.
Deputy Parker. Thank you. Deputy Parker, yes, ma'am.
Wondering if we could get the speaker like turned towards us.
Oh, can you turn the speaker? There you go.
They don't mind.
Deputy Parker, can you ask whoever's in there to kind of simmer down a little bit since we're having a trial? Is it the detainees or is it lawyers?
Just this side of town.
Yeah.
Yes, it's try.
Thank you. Thank you, Deputy Parker. All right, go ahead.
All right, for the record, starting back at 8 minutes and 5 seconds on the video. Well, now we don't have sound at all.
Did you make sure you click the little include audio?
Yes, ma'am, I did.
Yeah. May have to stop sharing, go back and try it again.
Bottom corner. Bottom corner, bottom right corner. Got an X on the. Oh, it was covered up by my screen, that's why. Thank you. And it's still on there.
Feet together. Arms right side, right? Look at tip of my pan, move your eyes and your eyes on you, not move your head, understand? All right. That was the question. Sir? Do not move your, do you understand? Move your eyes only, not your head. Yes, sir. All right. 12 to 15 inches. Come on my vehicle. Come on my vehicle. All right, you go right there. Stand right here. Left side. Left side, left side, left side. Yep. All right, you get right there. All right, same thing. All right. You tip my pen. Eyes only, understand?
So while we're watching that, in that first step that you did, what were you checking for?
First step I was checking for equal pupil size and equal tracking.
Pausing at 1026, why do you check for equal tracking and equal pupil size?
To see if there's any resting nystagmus, which is involuntary jerking of the eye.
Would that be indicative of any type of acute injuries?
Yes.
If it was present?
Yes. Right.
Okay. So when you failed to observe those particular things, did that mean that there was no head injury from a perspective of field sobriety evaluations?
From my knowledge, yes.
Okay.
No, eyes only.
Why do you have to keep telling him eyes only?
He keeps moving his head. Kept moving his head.
Did you instruct him to not move his head?
I did.
And is that indicative of somebody who, or I guess, is that failure to follow instructions
All right, so next evacuation cross.
common in people who are impaired?
Walk and turn. Well,
It
what
is.
you do? Stand right there. I want you to imagine. Imaginary line on the ground. You see one? It's imaginary line.
Stopping for the record at 11:36. So how many possible clues can you observe on this first evaluation, the horizontal gaze and stairs?
6 total.
How many clues did you observe in the defendant that evening?
6 total.
What's the next evaluation you performed?
Called the walk and turn.
Explain to the jury, please, how the walk and turn works, or how you instructed on the walk and turn.
Due to my training.
Okay.
As in,
And what are the steps of the walk and turn?
okay. So as I position myself in front of my car or anybody in front of my car, or if the ground is level enough to imagine an imaginary line, put your left foot on the front of the imaginary line, put your left foot first on the line, then put your right foot in front of your left foot in the heel to toe manner, arms by your side, and just stand there until I give you further instructions to move. At that point, when I give you instructions to move, so you take 9 heel to toe steps up your imaginary line, and then when you get to 9, leave your lead foot on the line, taking a series of small steps, coming back around, taking 9 more heel to toe steps back down your line. I instruct you to look down at your feet, count out your number of steps, keep your arms by your side, and don't stop until you are finished with the test.
How many total clues are there in that particular evaluation?
8.
All right. So starting at 11 minutes and 36 seconds for the record.
You see an imaginary line on the ground? Yeah, just imagine. Yeah, just imagine a line. Okay. You got it. Put your left foot at the beginning of that line.
Start with my left foot?
Yep. Left foot at the beginning of the line. No, wait. Hold on. Put your left foot at. You got your line? Just imagine a line. All right. Put your left foot at the beginning of the line. Put your right foot in front of your left foot, heel to toe manner. Starts too early. All right.
Listen.
Now just follow.
Can I ask you what's going on right now?
I'm just evaluating, make sure you're able to drive. Not obviously drive, but follow directions. All right. Follow me. See, this is my line. You got your line? Put your left foot in front. Put left foot on the beginning of the line. Your left foot. Follow. Put your left foot on the beginning. Yep. Put your right foot in front of your left foot, heel to toe. Stay just like that. Put your hands by your side for me. Stay just like that for me, all right? All right. What I want you to do when I tell you to begin, I want you to take 9 steps up your imaginary line. I'm gonna demonstrate. In the heel to toe manner. 1, 2, 3. I want you to take 9. When you get to 9, leave your lead foot planted on the line, take a series of small steps, coming back around, taking more 9 heel to toe steps back down your line. 1, 2, 3. I did 3, I want you to do 9, all right? But when I tell you to begin, hold on. Would you look down while you walk, count out your number of steps, keep your hands by your side, and when I tell you to begin, don't stop until you are finished.
Okay.
You have any questions?
Yes, sir.
All right, go ahead.
1, 2, 3,
Miss heel to toe.
4, 5, 6, 7, 8, 9.
Missing heel to toe.
1, 2, 3, 4, 5, 6,
Steps off
7,
line.
8, 9.
All right. Last evaluation. Called the one leg stand.
All right. So when you were talking into your mic pad, what were you doing?
I was stating the clues that Mr. White was messing up on.
Okay. And so every single time he missed a heel to toe, for example, because I heard you say heel to toe quite a few times. Do you count every single time that he misses heel to toe?
No, I just said that so I can remember.
Okay. And so how many total clues did you observe for this particular evaluation?
5.
And out of the how many?
8.
Okay. And so those 5 clues, were they all unique individual clues?
What do you mean when you say that?
So you didn't count 3 mishealed toes. It was he mishealed a toe a bunch of times, and that was 1 clue.
Correct.
Okay. Do you perform these evaluations on people who don't get arrested?
I do.
Okay. So not everybody that completes them is considered under the influence to the extent they're less safe when you do these evaluations.
Correct.
Okay. What's the next evaluation that you perform?
It's called the one leg stand.
And can you please explain to the jury how the one leg stand works?
I get up and demonstrate it. But
If
Like
well,
that
we're gonna
demonstrate-
see it on there. So just if you could explain instruction wise what you would tell him.
so I tell you to do is stand up straight, put your feet together, arms by your side. Then I tell them put your feet together, arms by your side. Oh, lift the leg of your choosing, left leg or right leg, whatever feels more comfortable. Lift it up approximately 6 inches off the ground, parallel to the ground, keeping your leg straight. Keep your leg straight. Eyes looking at keep stand up. Keep your leg straight. Here's by your side. Pick whatever leg feels comfortable, left leg or right leg. Approximately 6 inches off the ground, parallel to the ground. Yeah, keep your toes pointing forward. Keep your hands by your side. Count out in the manner of 1001, 1002, 1003. Look down whatever leg you decide to choose. Count out in the manner 1001, 1002. Keep your arms by your side. And if you drop your leg, it's all right. Pick it back up. Just continue. It's all right if you drop your leg. Pick it back up and continue counting till I tell you to stop.
All right. So how many total clues can you observe on this particular evaluation?
4.
4. And how many? Well, we'll get to that in just a moment. So for the record, starting at 13 minutes and 46 seconds.
Put your feet together for me. Hands by your side. All right, watch me. What I want you to do, I want you to lift the leg of your choosing, left leg or right leg, whatever feels more comfortable, approximately 6 inches off the ground. Keep your foot parallel to the ground. Keep your toes pointed forward. When I tell you to begin, I want you to lift whatever leg you decide to choose. I'm lifting my right because it feels more comfortable. I want you to look down at your leg, count out 1001, 1002, 1003. So I tell you to stop. Keep your hands by your side, and if you happen to drop your leg, just pick it right back up and keep counting.
Okay. How long?
I'm gonna tell you when to begin. You have any questions before I tell you to begin?
Yes, sir.
All right, hold on. Hold on. Begin. All right, you're good.
So what are the clues you can observe on that particular evaluation?
He lifted his arms to balance, put his foot down. Was swaying.
And so how many total clues did you observe in Mr. White with that evaluation?
3.
At this particular time, Trooper Fernandez, had you made any conclusions?
I did.
What conclusions did you come?
He was intoxicated.
What was the next steps after that?
I placed him under arrest for DUI.
And once you placed him under arrest for DUI, what did you do?
Put him in the backseat of my patrol car, and then I read him implied consent for suspects age 21 or over. A green card that I read, you gives you the option, whether you want to or not, to take a state administered chemical test of your blood, breath, or urine.
And what did you request in that particular night?
I requested for blood.
And what was the defendant's response?
No.
Where did you take him after you all, I guess, left the scene of the incident?
Grady Hospital to get cleared,
So,
if I'm not mistaken.
and did they clear him? If you need to refer back to your.
I do. Oh, real quick.
Recollection. May I approach your honor?
Yes.
Well.
I have notes. Can
What's that?
I look at my notes real quick?
Yeah.
Okay.
You have it. Ms. Berry,
Well,
you need to look at what he's
I was
looking
gonna
at?
say his notes are,
I'm familiar with it.
okay.
Okay, go ahead.
Yes.
So has your memory been refreshed?
Yes.
Okay.
I
So,
to
when
get
you-
it cleared.
When you took him to Atlanta pretrial, which was at Grady Hospital, where, or I guess, what was the outcome of that visit?
Just to be medical cleared due to the fact that he was involved in a traffic accident.
Okay. And then where did you take him after that?
Atlanta Pretrial Detention Center.
Okay. All right, 1 second, Your Honor. So I just want to go back to the beginning portion of your testimony, just really quickly. When you were speaking with Officer Lane, did he tell you how big the bottle of liquor was?
Yes, I was advised.
And how big was it?
No objection hearsay.
He was on the stand yesterday and testified to it. He was available for cross-examination, Your Honor.
Yeah, I'll allow it.
How big was it?
1.75 liters.
What kind of liquor was it?
Casamigos.
And have you ever seen a 1.75 liter bottle of Casamigos?
I have.
Okay. And Judge, for demonstrative purposes, the state would like to introduce State's Exhibit number 1. It is a demonstrative example of the bottle. I know we discussed the judicial notice with the thing, but I wanted the jury to be able to a complete understanding of it.
Okay, is that gonna, actually, the video is number 1.
I'm sorry, State's Exhibit number 2, excuse me.
All right, any objections?
Yes, again, hearsay. This was something that was not observed by the trooper. This was observed by the other officer.
I'm using it for demonstrative purposes. I do have case law to say that it does not have to be the exact, and it can be for demonstrative purposes. And if Your Honor, may I approach with case law?
Sure.
Very briefly. And I do have a copy for defense counsel with relevant portions highlighted. And if you look on page 7, Your Honor.
Either one, sorry. All right,
On page 7, Your Honor, the burden is on the party to offer demonstrative evidence to lay a proper foundation, establishing a similarity of circumstances and conditions. Now, Your Honor, the state has introduced through Officer Lane the size of the bottle, the fact that he observed it. We also have brought up through Trooper Fernandez that he was familiar with the bottle that that Officer Lane told him about, and he has experience with knowledge of the size of the bottle, and he has seen one before. Thus, I think he can authenticate that this is a 1.75 liter bottle of Casamigos.
Ms. Berry?
Again, objection, Your Honor. It's a speaking objection. I mean, he's already made the point to the jury, so.
Okay, well, I'm gonna allow it because he did say it was 1.75 liters. I mean, that's what he recognized it at, and that's for the state, that's a 1.75 liter bottle of Casamigos. So I'll allow it for demonstrative purposes.
Thank you, Your Honor. May we publish?
Yes.
So. No further questions for this witness, Your Honor.
All right, Ms. Berry Cross? Everybody good? No one needs a break, right? Everybody good?
Good morning.
Warren,
Okay, so going back to where you started your testimony. So you said in May 2022, how long had you been involved in law enforcement?
approximately, at my current job, you state,
Well, I guess you said as of today, you've been in law enforcement about 3 years?
yeah, man, approximately about 3 years.
Okay, so were you pretty new at the time that this happened?
I was.
Okay. When did you complete, like, I guess, trooper school?
Started in October, graduated in April of 21.
So you started October of 21 and graduated in April of
I'm sorry, I started October 20, graduated in 21,
21.
April 21.
Okay. So when this happened in May of 2022, you'd been a trooper about a year.
Yes, yeah.
Got it. And I guess in your role as a state trooper, you do a lot of traffic enforcement, right?
Correct,
And you work a lot of accidents?
correct.
Do you have any specific training in accident reconstruction?
I do levels 1 through 5.
And when did you get that training?
It was spread out. I believe I completed 5 beginning at the end of last year. I finished level 5.
Okay. So, but you didn't actually investigate the crash in this case, right?
I didn't.
That was the Atlanta police officer who did that?
It was.
Okay. So you were not involved in that part of it at all?
No.
And you did not actually see the accident, you just responded after the fact, right?
Right.
And at this point in time, when you did this investigation, how many DUI investigations had you done at that point?
This was my first one.
First one, okay. And I guess but you've worked a lot of wrecks now over the past 3 years. In your experience, is it pretty typical when someone is in a car accident, whether big or small, that they can have an adrenaline rush, be kind of shaken up?
Yes.
That's pretty common. And it's also pretty common that people might not necessarily know the full extent of their injuries when they're initially in an accident, right?
Correct. I'm not a professional, but I'm assume so.
Right. And to your knowledge, Mr. White was not evaluated by a medical professional on scene, right?
He refused.
He said, no, he's good?
Yes.
Okay. Though you mentioned that you medically qualified him before doing the test of his eyes. What did the medical qualification consist of?
Asked him if he had anything wrong with his head, neck, back, legs, or anything of that sort before I administered the test, and he stated no.
Okay, so it was basically just asking him
if he was
Right.
okay.
Okay, so it was not like a medical test that was done.
No, ma'am.
Okay, all right, very good. And you would also agree with me that you've investigated plenty of accidents where there's rear end collisions, right?
Correct.
And a lot of them have nothing to do with alcohol or drugs, right?
Yeah, I will draw.
Can you restate the question?
Many motor vehicle accidents are just because a driver is distracted, not having to do with alcohol or drugs, right?
Depends on the situation. It just depends on what I roll up on.
Okay, so every accident you roll up on usually involves alcohol or drugs?
No.
No, okay, all right. All right, so let's talk about then the tests. Well, I guess, so you're there to do a DUI investigation. And this was you were wearing a mic and you had the camera, I guess, was in the dash of your car. Is that right?
Yes, I have body mic. Yes.
Okay. I guess let me ask you, did you ask Mr. White, I guess, where he was coming from and where he was going?
I did not.
Did you ask him what he had to drink that night?
I did not.
Did you ask him what he had to eat?
I did not.
Did you ask him who he was with?
I did not.
Did you ask him how long he had been up, how long since he last slept?
I did not.
So you didn't really ask him any questions before starting these field sobriety tests, right?
Correct.
And don't you think that would have been important information to ascertain?
Yes.
Okay. All right, so we get into the field sobriety test. So you said you asked him, hey, do you have any problems, medical problems? And he says no, right? Correct?
Correct.
And then you said you determined that he didn't have any concussion or head injury because you did a pass and his eyes looked okay? Did I understand the testimony correctly?
You say that again, I'm sorry?
I guess, how did you rule out the fact that, is it your understanding his airbag is deployed?
Yes.
And how did you rule out the fact that he had hit his head or had a concussion or anything of that nature?
Just looking at him, he wasn't bleeding, no bumps on his head.
Okay. So you can't say with any certainty if he did have some kind of head injury, right?
Not internally.
Because you don't, I mean, you don't have any medical training, right?
Correct.
Okay. All right. So let's talk about this first test, the horizontal gaze nystagmus. So you said you're looking for jerking of the eyes, right?
Correct.
Now, did you learn in your training? I guess there are many other kinds of nystagmus that exist in the world, right?
Correct.
What are some of those other kinds of nystagmus?
I know we got vertical and excuse me. Vertical's on me. I can think of
Okay.
right now.
I know before you mentioned resting nystagmus. So nystagmus just means a jerking of the eyes, right?
Yes.
So some people always have resting nystagmus, right? Like their eyes just jerk naturally.
Correct.
Correct. And what about, are you familiar with optokinetic nystagmus?
No.
You didn't learn about that in your training?
No, not that I
You ever
recall.
learned in your training about nystagmus that's caused by flashing lights?
Yes,
Yes. So is it a good practice to usually to turn off lights, right?
it is.
Yeah, okay. Or what about, are you familiar with fatigue nystagmus?
Yes.
And, or caloric nystagmus? Or I guess, are you familiar with any nystagmus that's associated with conditions, medical conditions with the inner ear?
Jay's actually, she's, well, I asked and answered.
I'll move on. I'll move on.
Thank you.
Okay. And then you also, I guess, when you were taught how to do this eye test, looking for nystagmus, I guess there's a very prescribed way you're supposed to do it, right?
Correct.
Because if you do too many passes, if you do the passes, back and forth passes too fast or too close, that could compromise the results that you're looking for,
Correct.
right? So also too, if somebody moves their head, if they don't actually focus on the stimulus, then that could compromise the results also.
I'm sorry, can you repeat that?
If somebody moves their head and doesn't keep their head straight, that could also compromise the results, right?
Yes.
So I think you testified that he was moving his head.
Yes.
So if he did move his head, what is the remedy to make sure the test is still accurate?
When he moved it, I'm sorry, can I?
No, that's okay.
I'm sorry, repeat the question, I'm sorry.
Well, if he moved his head, did you redo the pass to look for the nystagmus or?
I stopped. I stopped, stayed where I was at, and then I told him not to move his head, and then I did the pass again.
Are you aware, are there rules though? Can you just keep doing the passes indefinitely until you see the nystagmus?
No, that's not what I was doing. I was just letting him know to just keep his head still and just move his eyes only.
But you said you're familiar with fatigue or endpoint nystagmus, which basically can be caused by too many passes, right?
I believe it's at the same time. When I stop and do it again, I'm just I'm not doing it and keep telling him I stopped, and then I told him his eyes only, and then I continued on.
Couldn't really tell because he was faced away from the camera, but then did you do passes? So you did horizontal passes to see horizontal gaze nystagmus, but then did you do passes to see vertical gaze nystagmus?
Yeah, that was part of it.
Did you see vertical gaze nystagmus?
I don't believe I did.
Because you would have marked that in your report, right? And you did not mention that in your report?
Correct.
Okay. And what is vertical gaze nystagmus?
I believe when the person is heavily intoxicated.
So it'd be a high dose. You would see vertical gaze nystagmus if it was a high dose of alcohol for that particular person, right?
Correct.
And there was no indication that that was indicative in Mr. White, right?
Correct.
Okay. All right, let's talk about the walk and turn evaluation next. So that's when we take, you said, well, I guess there was some issue where he started too soon.
He did.
Is it considered a clue of impairment if they start before, like you say go, right?
It is.
So is that one of the clues that you indicated made you think he was under the influence?
I believe I marked that correct.
So they are supposed to, well, I guess, would you agree with me that outside the test, Mr. White appeared to have a normal gait? He was standing, he was polite, he wasn't giving you a hard time, he wasn't falling over, right?
He was swaying. He was swaying.
Okay, all right, so you're saying that he was supposed to wait in ready position? So what is ready position?
So he was supposed to imagine a line in front of him, put his left foot on the beginning line, and then put his right foot in front of his left foot in the heel toe manner.
And then he's supposed to wait for you to demonstrate, or he can't?
I apologize, Jack. This is kind of testifying.
Yeah. You're testifying with your movements.
Oh, okay.
If you want him to demonstrate, okay.
Understood. So he is supposed to wait in with heel to toe. And then you tell him to go. Is that accurate?
Yes, I demonstrate. Wait in that position, then I demonstrate so he knows I could do it while I'm explaining it, and then he starts the evaluation.
She was able to walk in a line, make 9 steps, turn around and walk back, right?
He did with some clue with also missing parts of the dam. He like stepped offline, and 3 clues that he did miss.
But I guess there's a total of 18 steps, right?
Yes, back and forth.
So how many steps did he make correctly and how many steps did he not make?
I believe from my notes he did 9.
He did
He did 18 total.
18 total. Okay. But I'm saying, but so most of them were heel to toe, right?
He missed some. He missed a few during those 9. I don't know at what point he did, but that's why I was narrating to my mic when he did miss it.
So would you agree that I guess since this is a standardized evaluation, you don't factor in if somebody is naturally clumsy, if somebody is nervous, if somebody has different health conditions. It's all scored the same way, right?
Yeah, when I medically cleared him, he said he was fine. So.
And then let's talk about the turn. So if somebody does 9 steps and they just get to the end of the line and they just turn around in a regular way, that would be a clue of impairment, right?
Yeah, that's wrong because I didn't say turn how you would like. I take a series of small steps coming back around.
So they're supposed to keep 1 foot planted and then take a series of small steps around?
Correct. Back to their line and walk back down.
So it's sort of like a spin type turn they're supposed to do.
I would indicate it's like a slow turn.
So it's, I guess the way you were asking the person to walk and turn is not the way somebody typically walks and turns, right?
Depending on how somebody walks and turns.
Right, okay. All right, let's talk about the 1 leg stand. So he clearly had trouble doing the 1 leg stand.
Correct.
So can you go over the instructions again? Someone is supposed to, with you timing them, right?
Correct.
An officer timing them. They're supposed to keep arms at their sides and lift 1 foot at least 6 feet off the ground minimum.
Yes, 6 inches. 6 inches off the ground.
And then they have to keep their leg straight out
Yes,
and their toe pointed
forward. Correct.
forward. Okay. And then what did you say? They're supposed to keep their head back or look at their?
No, I told him to look at whatever leg he decides he chooses to lift, left or right, whatever feels more comfortable to him.
Okay. And would you agree that there are some people who would have a hard time doing this, stone cold sober in their on their birthday in their backyard with their friends around? That this could be nerve wracking for people.
Lifting your leg. I'm sorry. Can you rephrase the question? I'm sorry.
That this could be hard for some people, just might be naturally clumsy and have a real hard time doing this.
Sure, I guess.
And you would agree this is a stressful situation. There's lots of police cars and traffic and flashing lights, right? We saw the video.
Oh, what's that? He said speculation. What was your response?
Well, I guess in his training and experience, I'm asking if this could be hard for people. You know,
And in your training experience, do you know if that would be hard for some people to do?
To lift their leg.
when there's a lot
Like,
going on.
One leg stance.
Would it be hard to lift? I'm sorry, I'm just not understanding.
Hold on, I'm okay.
Okay.
I'm sorry.
Okay. All right. So I guess just lastly, you don't know anything. I mean, I guess there was no further evaluations with Mr. White in terms of establishing what I call baseline. You don't know about his educational level?
I do not.
Correct. Did you ask him, what I call ABCs, 1, 2, 3s, who's the president, anything like that?
I did not.
Okay. And you don't know his natural, you don't know if he's, I guess you don't know anything about him, right? Other than what we saw on that tape.
Correct.
Okay. So let's then talk about, so you placed him after the one leg stand, you placed him under arrest. And you said you took him to the police car. So he's under arrest at this point, he's handcuffed.
Yes.
And then you read him a card, you said, implied consent?
Yeah. Yes, I have it if you'd like me to read it.
Okay, you want to read it because you said you asked him for a blood test. So
I
if you want to
did.
read the card that you read to him?
After I placed him and put him in the backseat of my car, I asked him how old he was, and then I read him the implied consent notice for suspects age 21 or over. She didn't read it.
Judge,
Yes.
I would just ask that if she's gonna use this or read from it, that it be placed into evidence first.
And he's on, yeah, or I guess I'm gonna have to keep his card though, so
If
we can make a photocopy of it.
To a photocopy of it, then I can make a photocopy before we leave.
I certainly will stipulate.
All right, we won't keep your card, we'll just make a photo.
Okay.
Okay, after the hearing, after the trial, we'll do it.
And if you want to stipulate this to the color of the card, just for record purposes.
Ms. Berry,
It's green.
okay, so it's green, but we'll make a non-colored photocopy
Okay.
of the card, all right? That way you won't have to give up your card.
Okay. The state of Georgia has conditioned your privilege to drive upon the highways of this state upon your submission to state administered chemical tests of your blood, breath, urine, or other bodily substances for the purpose of determining if you are under the influence of alcohol or drugs. If you refuse this testing, your Georgia driver's license or privilege to drive on the highways of this state will be suspended for a minimum period of 1 year. Your refusal to submit to blood or urine testing may be offered into evidence against you at trial. If you submit to testing and results indicate an alcohol concentration of 0.08 grams or more, your Georgia driver's license or privilege to drive on the highways of this state may be suspended for a minimum period of 1 year. After first submitting to the requested state test, you are entitled to additional chemical tests of your blood, breath, urine, or other bodily substances at your own expense and from qualified personnel of your own choosing. Then this is when I ask, will you submit to the state administered chemical test of your blood?
And you said he said no?
Correct.
And is he entitled to make a phone call or talk to a lawyer about what he wants to do?
He's not.
Okay. And would that have changed, again, he's already under arrest in the back of your patrol car. Would that have changed anything if he had said yes to a blood test?
If you wanted to change his answer, I would have allowed it.
No, but I'm saying you wouldn't have unarrested him, right?
No, I'm sorry, no.
You've already, okay, so, but then you take him to Grady anyway, because you want him to get checked out?
The jail won't take somebody who's in an accident. So they have to go to some type of hospital and get cleared from a medical professional before the jail will take them.
So you're allowed to get a search warrant and ask a magistrate judge to sign an order saying that he has to give blood, right?
No, he doesn't have to. I read him this, so this is his choice. If he says no, then.
Right, but I'm saying you asked him if he said no, but even if he says no, an officer can get a search warrant and basically make someone give a blood test, right?
If you want to go that far, correct?
Yes, okay. But this was the end of your investigation, right?
Correct.
Okay, thank you. Nothing further.
All right, anything else from the state?
Yes, please read the rest, Your Honor.
We'll put the card in as defense 1.
What happened?
I guess the card will be put in as defense 1, Ms.
Oh.
Berry? Well, a photocopy of the card.
Your
Well,
defense is.
The state asked for it to be admitted. I mean, D1 is fine, but
Okay, so state 3. Okay, sorry. All right, go ahead.
All right, Trooper Fernandez, so I just want to clarify, did you observe any injuries visible on Mr. White?
I did not.
And did he ever complain of any injuries?
He did not.
Did he mention anything about his head hurt?
When I first approached him, I said, was there anything wrong? Do you have any head, neck, back injuries? He said he did. Then I asked, well, before the accident, he said no.
Did he ever request medical treatment?
He did not.
Okay, and did the fact that you didn't ask about what he ate or drank that
I'm gonna
day?
object to leading.
So defense counsel asked a specific question and okay, I'll
Just rephrase.
rephrase it. Yeah. Would eating or drinking have a significant effect on his performance on the field sobriety evaluations based on your knowledge and experience?
No.
Are you required to perform every single evaluation that you could?
While doing efforts.
So if she asked you questions about ABCs 1, 2, 3, are you required to do every single battery of tests?
No.
Okay. Based on your investigation on the scene and the totality of circumstances, what was your basis for concluding that he was under the influence to the extent that he was a less safe driver?
The clues I observed.
Okay. Outside of the clues that you observed, did you also base anything off of any observations that you made of Mr. White?
Bloodshot eyes, swaying, strong odor of alcohol emitting from his breath when we were talking. Slurred speech, things of that nature.
When you were in basic, or I guess when you were in your SFST training or the field sobriety training, what did they tell you about the lights when you're performing these evaluations?
They said it's best to cut them off because that could have an effect on the eyes.
And did they tell you had to cut off every single light, or was it just certain lights that they had to cut off?
Just certain lights.
Okay. And did you ensure that your lights were cut off?
I did.
Okay. And one last thing, I just want to clarify, are you able to explain to the jury the difference between seeing results on VGN, which you said you did, and seeing results on the HGN?
So just like, well, VGN is vertical gaze and stagger is kind of like a jerk, a very distinct jerk up and down, while left and right is still distinct, but.
So let me ask you this way. Just because you didn't see clues on the VGN, did that invalidate the clues on the HGN?
No, it will not.
Okay. No further questions at this time. I will pass the witness, Your Honor.
Nothing further, Your Honor.
I would ask that this witness not be released until after the close of the defendant's case in chief.
Okay, thank you, Trooper. You can step down and we'll just hang out there for a little bit, okay?
Okay.
Court from the order remain seated.
So stand by. She's bringing me copies of the jury charters.
Awesome. Thank you.
Your Honor, I guess while we're waiting on those, I have a motion to eliminate about closing argument.
Mhm.
During Trooper Fernandez's direct, yes, he referenced some hearsay, not in evidence, that the initial officer told him that Joshua was pouring out a cup, there was a red cup or he was pouring out a cup.
Mhm.
It was in response to one of the questions he was asked. I would ask because I didn't object to it at the time because I thought I would have drawn more attention to it. I would ask that the state not argue that point or bring up the cup in closing.
So I think in reference to anybody pouring or emptying liquids out of a cup, because I kind of have the same thoughts on that. I thought pointing that out might have made it a little bit worse. But Officer Lane did mention that he saw the red Solo cup next to the car. So I think we should be able to reference the cup itself, but not the fact that anyone was pouring anything out of it.
Well, again, just because of that coming into evidence, I mean, I don't know I guess the state could say yes, that there was reference. I mean, that wasn't evidence that he saw a cup.
So just that he saw a cup
Yeah, just that there was a cup, but I don't want them to make any then
leaps to pouring
leaps to,
stuff out.
that he was
So,
walking around with the cup or drinking from the cup or that was seen by anyone at the scene.
all right, so you can mention that he saw a cup, or there was a cup by the car, but nothing about pouring or tossing or what have you.
Understood.
Thank
And
you.
I do want to clarify that any inferences that the state draws from that are still appropriate such that that cup came from his vehicle. Not saying that he was drinking it, but the cup being next to the vehicle right after the accident, it was observed by the officer. I think it is appropriate to make that inference. And I just want to make sure that we don't have any issues during closing with that.
Ms. Berry?
Again, because of the hearsay coming in, I just feel like I would ask that the state not be permitted to talk too much about the cup, other than, I guess, there was a cup observed on scene, which is what the initial officer testified to.
I mean, I guess they can infer.
Because, I mean, we didn't see him consuming any alcohol, but the officers did smell the odor of alcohol, which would allow us to make that inference that he consumed alcohol. So I imagine it would be similar to that in that there was a cup next to the car.
What's your plan? What are you gonna say about?
Well, I mean, about the cup in general, that's another observation in the totality of circumstances that led the officer to believe that a DUI investigation was necessary. I'm not gonna get up there and say, oh, he had that empty Solo cup. And I mean, even in the reports, it specifically says there was a red ring, a smoothie-like ring around the cup. So there were clearly contents in the cup, but I'm not getting into all of that. All I'm getting into is that was another initial observation that led to the development of the probable cause for the arrest for DUI.
Or for APD to call the trooper?
Yes, for APD to call the trooper, correct, yes, ma'am.
Okay, well, allow that, but tread lightly.
Yes, ma'am, will do.
So I guess we can go ahead and bring them back in and let them know that he's not gonna, the state rests, and then we'll just printing out some jury charges, okay? How about we do that? Do you want us to dismiss the trooper?
One more time.
Just you're gonna rest, right?
Yes, so you,
So
yes.
I'll tell you, why don't we do this? We'll bring them in. You can rest, we can release the trooper. We can let them hang out back there, and then we'll do our charge conference real quick, and then before their lunch gets here, hopefully can come in, charge the jury, you can do your closing arguments. Is that good? Kind of keep it moving?
Ready?
Man,
I just want to keep it moving. What do you think?
us
Barry?
too.
I hate just sitting here and doing nothing.
Ready?
Yes, ma'am.
All jurors accounted for, Your Honor.
All right. Mr. Holland, you recognize this is your jurors?
Yes, Your Honor.
All right,
These are the
and
state jurors.
Ms. Berry, you recognize these folks as your jurors?
Yes, Your Honor.
All right. Let's see, anything else from the state?
No, Your Honor, the state rests his case in chief.
All right, Ms. Berry, anything from the defense?
The defense rests.
All right. You can tell the trooper he can be excused. No one has objections, right, to the trooper?
No.
No objection.
All right, you gave him back his card. Okay, so what we're gonna do right now is go over some jury charges. I think I probably got about, let's see, 10 pages. So we'll let you folks sit back there. Have they gotten your lunch order? Okay, we'll let you sit back there. They've called that in. So as soon as we're finished, which it shouldn't take too long, we'll bring it back in. I'll charge you folks with your job. They'll do their closings and then we'll let you go deliberate, okay? And in the meantime, Don't talk about the case yet until you've heard everything, all right? Thank you. Anything?
Questions?
You have questions? Okay. All right, so if you folks want to step back out, we'll go over the jury charges and then we'll get you back in here.
All right, so
So, Ms. Perry, you also got a copy of his motion for a special jury charge, a curative charge?
I think I'm missing a page.
From.
Page 2?
Flip it.
Oh, it's on the
Double
back.
sided.
Oh.
Yeah, she printed it front and back.
Right.
He likes to say. Yeah, for sure.
And the parts that are highlighted, these, whatever changes we want to make, we'll talk about it. Because we weren't sure whether or not he was going to testify.
Okay, Judge, under the witnesses section, it says testimony in this case will be given by witnesses determined an expert. There were no expert witnesses, I guess, tendered in this particular matter, so I don't know that giving that would be appropriate to the jury.
I concur. I would ask that that be removed.
So will you keep the part of the witnesses that's not highlighted, correct? Or do you want to strike you got to have something about the witnesses. You want to strike the first paragraph?
Yeah, just the first paragraph.
And then we can strike the word expert
Yes, ma'am.
from that second paragraph, Ms.
Second
Barron?
paragraph, first sentence. Or I guess the second sentence too.
Yes.
Let's see. Okay, we'll strike the word. Or what we'll do, okay, so on the first, we'll strike the whole first paragraph, that second paragraph, testimony of all witnesses, how about that?
Mm-hmm.
So of and we'll just.
Right. They had no concerns with the jury charge, proposed jury charges from the court.
Okay, with the exception of the two changes we made, right? Ms. Berry?
I guess my proposal would be if where it says, starting where it says, in the state's motion for special jury charge,
Uh-huh.
where it says pursuant to OCGA, through,
Oh, number one on the
yeah,
bottom,
number
okay.
one.
Uh-huh.
I guess if that be inserted on page 7, after the paragraph where it says a witness, this is under the DUI less safe charge before we get to the possession of an open container of alcoholic beverage. That could be read there. I mean, I don't want it to be introduced as this is a special jury charge or taken out of context from the rest of the jury charge. I think it's an accurate statement of law.
You're talking about inserted in these?
Yes,
Oh, okay, so inserted after possession of open container,
before possession of open container, at the end
Okay.
of,
right before.
there's that paragraph that says a witness who satisfactorily shows. Make that the next paragraph that says pursuant to OCGA 40-6-391A1.
We could just copy and paste it
Just
there.
cut and
as
paste it
opposed-
right in there, yes.
And I guess we'll title it,
I would just keep it under the less safe to drive. I don't even think we would need.
yeah,
That's the right.
just add that additional paragraph.
Because I think it just kind of flows from that.
Sure.
Agreed.
All right, so we'll take the special jury charge, put it right there at the end, just before possession of open container, right?
Yes, thank you, Your Honor.
All right, and then make sure we're okay. If you can see what I'm striking, y'all want to just look at this piece of paper, see what I struck on this other paragraph?
May we approve?
Yes. Oh, and here goes the verdict form too. And I'll get Ms. Davis to make. I've read it like 4 times. And I didn't see expert. The first paragraph and then the wording in that second paragraph. You see it?
3400.
All right, and how are we with, the verdict form's good?
Yes, ma'am.
Okay. All right, let me let Miss I'll let Kim change this real quick, so, and print out our copies. So what do you think, like 15 minutes, 10, 15 minutes, maybe? I guess 10 minutes, however long it takes for just to reprint, because you're gonna lose 6 copies. Okay.
Defense is ready.
All right. Be right back, Madam Court Reporter.
All jurors accountable for your own.
All right. Ms. Collins, you recognize this is your jury? All right, Ms. Berry?
Yes, Your Honor.
All right, all jurors are here and accounted for. All right, so, and is defense resting their case?
Yes, defense rests.
Okay, so that's the conclusion of the presentation of evidence. I'm going to read you some jury charges. They're going to do their closing arguments. We'll send you back to deliberate and eat your Jimmy Johns.
Okay.
All right, all right. You also have copies of this back with you, okay? This is the state of Georgia versus Joshua Elijah White, accusation number 23 CR 006-398Y. I'm filling in for Judge Susan Edline. Ladies and gentlemen of the jury, you've heard evidence in the case of the state of Georgia versus Joshua Elijah White, whose accusation number 23 CR 006-398Y as in Yankee is charged with 1 count of driving under the influence less safe to drive and 1 count of open container of alcohol, which are misdemeanors in the state of Georgia. To this accusation, the defendant came into court and pled not guilty. The accusation, together with the defendant's plea of not guilty, form an issue that you are determined. The accusation and the plea of not guilty are not evidence and should not be regarded as evidence by you. I will now charge you with the law which you should apply to the facts as you find them to be from the evidence presented. You should consider these charges along with those I have previously given you. You will be given a copy of the charges to have with you in the jury room. Presumption of innocence. The defendant enters this trial in this case with a presumption of innocence in his favor. And that presumption remains with him throughout the trial of this case until and unless the state produces evidence in your presence and hearing sufficient to satisfy your minds beyond a reasonable doubt of the defendant's guilt of the offenses charged. Burden of proof. No person shall be convicted of any crime until each element of the crime is proven beyond a reasonable doubt. Facts and circumstances which merely place upon the defendant a grave suspicion of the crimes charged, or which they merely raise a suspicion, speculation, conjuncture of the defendant's guilt are not sufficient to convict. The burden of proof rests upon the state to prove every material allegation of the accusation and every essential element of the crime charged beyond a reasonable doubt. There is no burden upon the defendant whatsoever, and the burden never shifts to the defendant to prove his innocence. Defendant in a criminal case is under no duty to testify, or present any evidence tending to prove his innocence. If he elects not to testify, no inference, hurtful, harmful, or adverse to the defendant shall be drawn by this jury, nor shall such fact be held against him in any way whatsoever. Reasonable doubt. While the law of the state requires to prove the defendant's guilt to your satisfaction beyond a reasonable doubt, the law does not require the state to prove the defendant's guilt to an absolute or mathematical certainty. A reasonable doubt is just what it says. It's a doubt of a fair-minded, impartial juror honestly seeking the truth. It's a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given arising from consideration of evidence, lack of evidence, a conflict in the evidence, or any combination of these. Simply stated, it is a reasonable doubt of a juror. If after giving consideration to all the facts of this case, and if your minds are wavering, unsettled, or unsatisfied, then that is doubt of the law, and you should acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you'd be authorized to convict the defendant. Jury as a trier of fact, you are the judges of the facts in this case. The facts you obtain from the evidence produced to you. The law you take from the court is given to you by a charge by the court. Any verdict in which you may render in this case should be derived from the facts you find them to be, applying the law as given you in this charge. It should be a verdict that speaks the truth. Evidence. The fact that the cases are to be determined by you from the evidence. Evidence consists of the testimony you've heard under oath and exhibits which have been admitted and will be with you in the jury room during your deliberations. Direct evidence is that which may be seen or heard otherwise directly the sense by smell, touch, or taste. If it's brought to you in the court, form of exhibits or testimony of the direct witness to such matters, it's the evidence that points immediately to the issue in question. When direct evidence by inference points to an obviously likely or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you infer other related or connected facts that are reasonable and justified in the light of your experience. If the evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions, sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved fact must not only be consistent with the theory of guilt, but exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based on circumstantial evidence than upon direct evidence. Whether dependent on direct evidence or circumstantial evidence or both, the test is whether there is sufficient evidence and whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you must convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the whole jury to decide. Witnesses. You're required to accept the testimony of any witnesses. Testimony of all witnesses is to be given only the weight and credit as you think it's properly entitled to receive. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their means, opportunity of knowing the facts in which they testify, the nature of the facts in which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Your assessment of trial witnesses' credibility may be affected by comparing or contrasting the testimony to statements or testimony of the same witness before the trial started. It is for you to decide whether there's reasonable explanation for any inconsistency in a witness's pretrial statements, testimony when compared to the same witness's trial testimony. As with all the issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. To impeach a witness. Sorry, Judge Edline's monitoring my progress and sent me a message. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. In determining the credibility of the witnesses and testimony by them in court, you may consider where applicable evidence offered to attack credibility or believability of any such witness. Venue. The law provides that criminal action should be tried in the county in which the crime was committed, except otherwise provided by law. In the prosecution of this case, in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in the county which the evidence shows beyond a reasonable doubt that it may have been committed. Venue, that is, the crime committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt of any element of the offense. Venue must be proved by direct or circumstantial evidence or both. Definition of a crime. The defendant is charged with a crime against the laws of this state. A crime in violation of the statute of this state is where there's joint operation of an act or omission of an act and intention. And criminal intent, I charge you that intent is an essential element of DUI and must be proven by the state beyond the reasonable doubt. Criminal intent does not always equate to a mental fault, guilty knowledge, or purposeful violation of the law. Criminal intent does not always mean an intention to violate the law, but simply means to intend to commit the act which is prohibited by the statute. Intent may be shown in ways provided to you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by the acts and conduct, or it may be, in your discretion, inferred from when it is natural and necessary consequences of the act. Whether or not you draw such inference is a matter solely within your discretion. To prove DUI, the state need not prove that defendant intended to commit the offense of driving under the influence, but the state must prove the defendant's condition of being under the influence of alcohol to the extent of impairment, and while in this condition, the intent to drive. This general intent may or may not be inferred from conduct of the accused in other circumstances. Driving under the influence of alcohol, less safe to drive. Shall be unlawful for any person while under the influence of alcohol to drive or be in actual physical control of any moving vehicle anywhere within the state. A driver or operator of a motor vehicle is under the influence of alcohol when the person is affected by alcohol to the extent that it is less safe for the person to drive than it would be if the person were not affected by alcohol. A driver who is less safe is less efficient, less skillful, less coherent, less able, less qualified, and less proficient. In deciding this issue, you may consider anything in the evidence that you find relevant in deciding whether the defendant was a less safe driver. Specifically, as a consumption of alcohol, you may consider, among other factors, the smell or lacks of smell of alcoholic beverages on the defendant's breath and or his person, and whether any tests indicate the presence of alcohol in the defendant's system. As to whether the defendant was less safe to drive, you may consider the factors you deem relevant, including but not limited to the actual manner of driving of the motor vehicle, the defendant's control of his mental or physical abilities, the defendant's demeanor, the physical condition of the defendant, and any testimony. We missed the one. Merely showing that defendant had been drinking or there was a smell of alcohol on the defendant's breath or person without the proof of the manner of driving ability to the drive is insufficient to prove that defendant was guilty of driving under the influence of alcohol. A witness who satisfactorily shows that he had the opportunity to observe and did observe the defendant may testify and render his opinion as to whether the defendant was under the influence of alcohol, whether because of intoxication or because the defendant was a less safe driver. While a witness may give his opinion as to whether the person was under the influence of alcohol, to the extent it was less safe for him to drive, that opinion must be supported sufficiently by evidentiary foundation. Pursuant to OCGA 46391, para 1, para A, para 1, the offense of driving while under the influence of alcohol to the extent that it's less safe has three elements. Driving under the influence of alcohol to the extent that it's less safe for a person to drive. This offense does not require the state to prove evidence of chemical analysis of the defendant's bodily substance as it relates to blood alcohol content. The Georgia implied consent law. A person who operates a motor vehicle upon the highways of Georgia or elsewhere throughout the state shall be deemed to have given consent to a chemical test of the blood, breath, urine, or other bodily substances for the purpose of determining the presence of alcohol. This test shall be administered at the request of law enforcement officer having reasonable grounds to believe the person had been driving a motor vehicle while under the influence of alcohol. This law authorizes law enforcement officer to designate the appropriate chemical test to be administered, breath, blood, urine, or other bodily substances for detection of the source of impairment as suspected by the officer. Defendant's right of refusal. While the Georgia implied consent law requires the defendant arrested for DUI submit to a chemical test, when properly requested to do so by a police officer, that person has the right to refuse to take any test. The exercise of the right of refusal in itself is non-determined as to whether or not the person was under the influence of alcohol. Nor is the defendant's refusal alone sufficient to warrant a determination that he was driving under the influence to the extent that he was a less safe driver. Defendant's refusal to permit chemical analysis to be made of his blood at the time of his arrest is admissible in evidence against him in a criminal trial. This refusal may be considered as a positive evidence creating inference that the test would show the presence of alcohol. Such an inference can be rebutted. It is up to you, the jury, to determine whether the defendant refused to be submitted to testing. Field sobriety evaluations in determining the defendant was drinking was less safe driver, you may consider the results of the field sobriety evaluations conducted in this case. Participation in sobriety evaluations is entirely voluntary. A person has a right to decline participation in the field sobriety evaluations. Field sobriety evaluations include the horizontal gaze and nystagmus, or HGN test. The HGN test is admissible as a basis upon an officer can determine the driver was impaired by alcohol. Other field sobriety evaluations, simply common sense evaluations of a subject's balance or motor skills. What inferences you draw from the performance of the HGN test or other field sobriety evaluations is entirely within your discretion. The results of the field sobriety evaluations in conjunction with other factors, including physical appearance of the driver, the presence of the odor of alcohol, and any inculpatory statements made by the driver, may form an appropriate basis for an evaluation by an officer and ultimately a jury as to whether the driver was impaired by alcohol and to the extent it was less safe for him to drive. A person, possession of open alcohol, open container of alcoholic beverages. A person shall not consume any alcoholic beverages or possess alcoholic beverage in container in the passenger area of a motor vehicle on the road. An open alcohol beverage container means bottle, can, other receptacle that contains an amount of alcoholic beverage that is open or has the seal broken in which the contents are partially removed. All right, we'll go ahead and let you folks do closing, and then I'll do the concluding comments. State.
State will reserve this right, and wait to open close, we'll just close code.
All right, Sperry.
All right. Okay, we are in the home stretch, ladies and gentlemen. Since this is a short trial, everything's heard to the past, 24 hours. I'm gonna keep this short, I'm not gonna subject you to some kind of multimedia PowerPoint presentation. I will do a little bit of recapping, but before I get to the facts I want to talk a little bit about the law. Particularly, I want to talk about the state's burden of proof in a criminal case. So, I know some of you said during jury selection, you were called as a juror not too long ago, and hopefully you're not called, knock on wood. Hopefully you're called not too soon after this. But I will say that this may be the only time in your life as a juror in a criminal case that you are going to make a decision in this way. You come back to court and you are selected for any other kind of case in this courthouse, like a civil prosecution, a civil case where there's a plaintiff and a defendant, two people are suing each other for $5 or $500 million or for property or land or just about anything else you could be fighting about in court. It's more of what you think of as the scales of justice. You hear from one side, you hear from the other side, you do a balancing, right? But in a criminal prosecution, the state of Georgia makes the case, right? And there's not that balancing. The state has to prove the charges, the essential elements of the charges beyond a reasonable doubt. And that burden never shifts to Joshua to prove innocent, to put up evidence, to testify, to say anything at all. Because the founding fathers of the United States of America and under Georgia law have said, when someone is charged as in a criminal offense, when life and liberty is on the line, you have to be really sure, right? I'd much rather, err on the side of someone who is guilty going free than of wrongly convicting an innocent man. So again, it's the state's investigation, the state's evidence, right? And similarly, it's a little bit different. It's a different framework. Again, this is the only time you're probably ever going to make a decision like this. If you were to leave court today and you stop at the grocery store and you buy toothpaste or you need toothpaste and you're looking at, one kind is the kind that you really like and makes your teeth extra white, has good flavor to it, but another kind, not quite as good, but it's on sale. Again, you do the balancing, but that's not the analysis we make. And it's hard to set that aside because that is the natural, way we make decisions on a day-to-day basis. So keep in mind though, the framework, you just heard the judge go over the law about, proof beyond reasonable doubt and what that means in the burden of proof. Have a packet of laws back there to refer to, but keep that in mind as you're going through your analysis because that is the paradigm, the framework to which you make the decision. And also I want to say that's unsatisfying. I mean, it's unsatisfying for me as a criminal defense lawyer to have to explain that and say, oh, I'm not here to prove innocence. I'm not here to put up evidence. I'm not here to do that. I'm just here to hold the state to its burden of proving guilt beyond a reasonable doubt. But again, and we'll circle back to it, but this is the officer's investigation. The officer needs to put up this evidence, and it's not satisfying. So I know I've talked a lot about reasonable doubt, but what does reasonable doubt mean? Well, reasonable doubt, as you heard in the law, and we could reference back to, it is just what it says. It's a doubt for which you can give a reason, right? It's not a vague or arbitrary doubt. We're not talking about, well, maybe it wasn't Josh, maybe it was, green aliens from Mars, Mars who came down. We're not talking about that. We're talking about just a doubt of common sense or reason. And there are three words, which you should look for, again, it's in the law. If your mind is wavering, unsettled, unsatisfied. Like that's sort of the theme of this case, it's unsatisfying. It's unsatisfying to not know things, right? But if you're unsatisfied as to the evidence presented to you in this case, you're unsatisfied as to what you know about what happened that night, then that lack of satisfaction, that is reasonable doubt. So a tire uncertainty, if you feel like I'm on the fence, I'm not sure what to do, you know what that is? Reasonable doubt. You heard it in the charge that you were given, they talk about, or the law is what we reference as grave suspicion. Even if you find the behavior gravely suspicious, something just doesn't sit right with you about, okay, it's 5 a.m, there's a bottle of liquor, grave suspicion, that's still reasonable doubt, right? It's not proof beyond a reasonable doubt, you still have that doubt. If you just wish you knew more, if you just said, well, I still have a lot of questions, you know what having a lot of questions is? Having a lot of questions is reasonable doubt. Even if you think, well, he's probably guilty, probably drank, probably out doing something, probably reasonable doubt. Assumptions, conjecture, all reasonable doubt. So again, I know probably thinking, oh my goodness, she's beating a dead horse here, but again, it's so important that we do this case from this correct framework. The other, and I'm going to go through some of the reasonable doubts in a moment, but the other part of the law I want to talk about is this concept of what they call DUI alcohol less safe. And when you get the verdict form, that's the main charge in the case. There's also open container, which I'll come back to too, but the DUI alcohol less safe, that's the way, people think about drunk drivers and stuff, right? But that's not what we're actually deciding here, and only lawyers and legislators would use the term DUI alcohol less safe. They make it really confusing, right? Because I hear the term, gee, was this less safe, right? Was this less safe driving? Yes, of course it was. Was I a less safe driver this morning because I'm nervous about this trial coming to court? So I'm distracted, it's Halloween and there's a lot of stuff going on in my kids' school and everything. Yes, I was a less safe driver. Is pretty much anybody who's in a car accident, especially a not fault driver, which you seem to be, are they a less safe driver? Yes, right? So we are conceding that Joshua was a less safe driver, but the state has to prove not that he is just a less safe driver, but that he was a less safe driver because he was under the influence of alcohol beyond a reasonable doubt. Now, could there be alcohol in a system? Is there evidence for there's presence of alcohol? Sure, but again, the state has to prove beyond a reasonable doubt he was under the influence of alcohol to the extent that made him a less safe driver. Not just that he was a less safe driver. Anybody in a car accident, as I said, is a less safe driver. So again, break that down because it's very I feel like cumbersome word. And the state may get up here and say, well, look, we don't have to prove that somebody is drunk. We don't have to prove that somebody's fallen down drunk, right? But they still have to prove that somebody is impaired. And just because you consume alcohol, just because you have consumed alcohol, just because you're a wreck, that doesn't mean the state has proved impairment beyond a reasonable doubt, that you are impaired by alcohol. So keep that in mind. Okay, so let's talk about some things. We have the driving, as I just mentioned, that's certainly less safe driving. But rear end collisions happen all the time. We talked about that during jury selection. You can be in a car accident. That doesn't mean it's because you were under the influence of alcohol. The officers even, begrudgingly admitted that. Alcohol, rear end collisions, extremely common in Metro Atlanta. And also too, this is 5 a.m. People could be tired, people could be dozing off a little bit. There could be lots of reasons absent, why somebody absent being under the influence, why this could happen. All right, so then let's talk about this investigation or lack thereof. I think there's a lot of just helpful information that could have been easily ascertained if just a few questions were asked. I mean, I would have wanted to know as a, if you're, as an officer, and again, it's the officer's investigation, they're the ones who have to get the evidence here. Where was he coming from? Was he dropping someone off? Where was he going? Did he admit that he was drinking? I mean, I suspect that the state is gonna start talking about, oh, there was a liquor bottle and a red Solo cup in the car. I guess their argument is that Joshua at 5 a.m. is driving around Atlanta and drank half a bottle of tequila. But just because, again, there's alcohol in the car, that doesn't mean that, I mean, we don't know anything about who consumed the alcohol, when it was consumed. Maybe it was from, last week, maybe there was other people, maybe he was driving people home. Maybe he had been the designated driver and was making sure people got home safe. There's just a whole lot that we don't know. And a few simple questions, in a police investigation could have answered that, and that just wasn't done. Also too, I will say the video is an evidence. So the state sometimes may show, portions of it that are unflattering to Mr. White. But at any point in time, you want to see a portion of it. You can knock on the door and ask the bailiff, and they will bring you back out. They'll put it on the big screen, and you can see. So you don't have to take, my word for it or anything. You can go back and watch any portions for yourself. But I'll submit this to you. On the walk and turn or one leg stand. Does he look right? No, I mean, he can't do the one leg stand. Which I'll come back to. That's tough. But in general, he's standing up. He's walking around. He's following instructions. In regard to his demeanor. I wish there was some more conversation. I wish there was the ABCs and 1, 2, 3s and who's the president and what time is it and, some other things to, just engage in conversation. But he's not giggly. He's not, he's not belligerent. He's not cussing. He's not, being rude. He's not, I guess, again, he's not being disorderly. I think the officer said, oh, he was swaying. And when I watched the video, he's standing up, like when he's doing the eye test, he's following the stimulus. He appears to be standing up straight. Certainly not the way you would expect, someone to be behaving if they were driving around drinking, half a giant bottle of tequila. So I think that he looks, normal and sounds normal and is appropriate on the tape. And as I said, the officer doesn't ask what I also call, in addition to the kind of time frame stuff, but also just kind of like the baseline questions. Like, is he someone who is, educated? Is he somebody who, is he from the area? Is he just here visiting? There's not any of these basic things that could have helped in an investigation if you're actually trying to build a case with proof beyond a reasonable doubt that you're under the influence. I also want to say that there was no, the officer said, well, we asked him if he needed medical assistance and he said no. Sometimes people could be concussed or have different medical issues, which if they're shaken after being in a car accident, they don't necessarily realize at first. It's not necessarily apparent. And that could also be some of the things that are coming into play here. I do want to say, a word about Trooper Fernandez, well, and I guess both officers. And it's that I don't think that they're bad officers, or actually they seem like they're very, good and, nice officers. But I do think that they have a confirmation bias, right? They have a hard job. They're both really new, first year kind of rookie cops. You heard it was Officer Fernandez's first arrest. And he comes out to a situation and, you never really know what to expect, right? Sometimes you have people who want to fight you or stab you, or, you're working all different kinds of situations. There can be belligerent people. There can be people who are seriously critically injured. So you're walking into difficult situations, but I do think that they have, an element of confirmation bias. And you heard from, I think what the first officer is Officer Lane, and he said, oh, look, it's, it was after midnight. If it's after midnight, people are probably coming from the bars or the clubs, so I'm kind of assuming it's alcohol. And I think everybody has their confirmation bias, right? Everybody has confirmation bias in their lives about things they're assuming. So I'm just saying that if you have a young man, it's 5 a.m, there's an accident, and then they see a bottle of, tequila in the car. I mean, I said that there's almost no way he's not being arrested, no matter, how he performed on the field sobriety test, because they have that idea. And, you saw basically the entire investigation on the video. It took about 15 minutes, and they made up their decision, and that was it. But, not everybody always gets it right, right? I don't always get things right in my job. But at the end of the day, too, it still comes back around to it's the officer's investigation, their job to prove their case beyond a reasonable doubt. The state makes the charges, and they have to get the evidence that they need. Let's talk about the HGN test. So you heard that, these field sobriety tests are all voluntary. Somebody can say, no way, I'm not doing them. But, Josh does do them and gets through them. And I think on the horizontal gaze nystagmus, it looks like, he followed instructions, he stood up straight. He followed the stimulus, he did what the officer, he looked fine doing, the evaluation on the tape to me. Now, of course, I wish he was turned the other way so we actually could see his eyes. That would be helpful. If the officer's saying he's looking for this nystagmus, this jerking. But then you heard the officer on the stand and say that there's lots of other things, he admitted there's lots of other things that can cause the jerking of the eyes, including flashing lights, including certain things, I asked about fatigue nystagmus and he was like, oh yeah, okay. So I think that just because if you see some jerking in the eye, that doesn't mean, that's a fail-proof test to say, oh yes, that's because somebody's under the influence of alcohol. And actually, he said when he was doing these kinds of passes, the vertical gaze nystagmus, which is supposed to show a high dose of alcohol or intoxication for a particular person, he didn't even see the jerking. So I would say that, we can't see what he saw. I wish we could, but based on, I would say, his lack of experience and then a lot of the other, he said he turned off his lights, but you can go back and look at the tape. There were lots of other flashing lights. There was lots of cars coming by. It's a busy area. I wouldn't say that this test in and of itself is particularly indicative of very much. And then I'll kind of group the walk and turn and the one leg stand. These are both dexterity tests, and I would say that they have kind of a convoluted scoring system. And I think that there's people who, on the best day of their life, on their birthday in their backyard with friends around, would maybe have difficulty balancing on one foot for 30 seconds. And I feel like it doesn't take nerves in the situation into account. Again, we don't know for certain if he, if Josh had, some kind of concussion or anything. But we do know that, I think it's common sense that if you crash your car, if you got hit in the face with an airbag, just a few minutes before this, the adrenaline is probably, pumping. I mean, I crashed my car on 285 a few years ago, during the day. I was at fault. I wasn't under the influence. Thankfully, everybody was okay. But when I got out of the car, my airbag deployed, I wasn't, seriously injured, just maybe some airbag burn. When I got out of the car, I was like shaking. Actually, another driver stopped, got out and hugged me because I was just so upset, right? Though not hurt. So I just feel like to go through something like that and then to be asked to do field sobriety and be asked to balance on one foot, I think that would be hard for almost anybody to do well. I wouldn't say that's an indication beyond a reasonable doubt that somebody's impaired by alcohol. I guess lastly, I just want to touch back on, the blood. Lack of blood tests. You did hear that the officer read, after he arrested Josh, he would put him in the patrol car and then asked him if he would take a blood test. And you'll see that, because it's in evidence, the card he read. And Josh said no. I think the state will argue, oh, well, he said no, that's on Josh. But again, burden of proof. And it's never Josh's responsibility to provide evidence, to provide a test. And you have a borderline case, you have a lot of uncertainty. It's the officer's job, then he could get a blood test. He could get a warrant and get a blood test, especially if they went to the hospital. Actually, they were at the hospital. It would have been easy to get a blood test. And the officer didn't do that. And if that was needed for their investigation, again, it's the state's case, and that wasn't done. So, based on that, we don't do convictions based on assumptions and probablys and conjectures, and I wish we knew more. If you have questions, if you're unsatisfied, that's reasonable doubt. And with reasonable doubt, that means, ask the DUI charge. We ask if you find, not that we ask, it would be your duty under the law, if there's reasonable doubt, find Joshua not guilty of DUI. I will say as an open container, is there evidence there was an open container in his vehicle? I don't think that there's reasonable doubt there. I think that the state probably has proven their case. So as an open container, if you want to find him guilty, then I think that, there's evidence. But again, that's your decision to make. Thank you, ladies and gentlemen.
All right. Mr. Hollins?
Yes, Your Honor. Yes, I am gonna bore you with a long conversation.
Oh, my.
I do feel it appropriate that you see these things in conjunction and not the spaghetti that's being thrown at the wall right So, we're here again to discuss State of Georgia versus Mr. Joshua White. He's currently charged with DUI less safe and possession of open container of alcohol, both misdemeanors in the state of Georgia. For DUI less safe, let's delve into this. There's a lot of words that were thrown at you all recently between the jury charges and defense counsel closing. So I want to hone in on the important things and keep you all focused. A person shall not, when you see the word shall not, it means you cannot drive or be in actual physical control of any moving vehicle while under the influence of alcohol to the extent, and this is the important part, that it is less safe for you to drive. Less safe means less efficient, less capable, less skillful, less competent, less qualified, and less proficient. What it does not mean we have to show is that the person is fall over drunk, falling out of their car, vomiting all over the place. We do not have to show that because you can be impaired and less safe to drive without being. The trier of fact, that is you, ladies and gentlemen of the jury. You can determine whether or not somebody is less safe by making observations of impairment. So not only the observations that you saw with your own eyes when we played the video, but also the observations that you can't see with your own eyes, that the trooper and our officer, Officer Lane, testified to, wrote in their reports, so that when today came, they would have a memory and the ability to recall these things that they observed on the scene shortly after it happened. You can look at the demeanor, the appearance of the defendant, his speech, his decision-making. There is no requirement of a chemical test under a DUI less safe statute. I want to make that very, very, very clear. The state does not have to produce any type of chemical test. The law doesn't require us to. And I also want to say that the state is not required, the officer is not required to go get a search warrant. They asked the implied consent, which our officer did. It is the defendant's choice whether or not he would like to produce that result or not. If he does not, the officer continues on with what he's going to do. Possession of open container of alcohol. I don't think there's going to be much of a dispute on this one. You cannot consume any alcoholic beverage or possess an open container where the seal has been broken. Now, alcoholic beverages could be a couple of different things. They could be beer, they could be wine, they could be malt liquor. There's a bunch of different things that the statute gives, but for our purposes, we've got an open bottle of 1.75 liters of Casamigos, which is tequila, which we know to be an impairing substance. Now, the passenger area doesn't necessarily mean in the passenger area. It means anywhere that's accessible in the car by the driver or any other passenger. And notice we don't have any other passengers in the vehicle, so the only person that's able to access that particular bottle would be Mr. White. Beyond a reasonable doubt. So again, it is doubt of a fair-minded, impartial juror honestly seeking the truth. But what I want to tell you is, it doesn't require us to show beyond a mathematical certainty, 99.9%. We don't have to show anything other than if you have a reasonable doubt. We don't want you searching for doubt, creating doubt. It is a reasonable doubt that comes into your mind based on the evidence that's presented by both myself and Ms. Barrett. And if you can reasonably conclude, even with the questions that you may have, based on the circumstantial and direct evidence, that Mr. White is guilty, you are allowed to find that we have proved our burden beyond a reasonable doubt. Now let's go into the facts that we established. So we had the initial encounter with Officer Lane. Officer Lane stated that around 4 or 5 o'clock in the morning, early in the morning, there was an incident that occurred at I-85 Georgia 400 northbound. The dispatch came in, the officer shortly arrived, and he determined, based on his investigation of talking to all parties at scene, that the defendant was at fault for the collision. And we don't call it an accident because when you get in the car, you drink and you drive, and you're driving to the extent that you're a less safe person and you cause a collision, that is not an accident. Now he has contact with the defendant. Officer Lane makes contact with him. He's asking him questions. His story's not making sense. Yes, he didn't ask him where he came from, but when he was trying to talk to him, the defendant was being evasive. He wasn't answering the questions. And it's kind of easy to say that he didn't know much of what was going on at that particular moment. He was having trouble with doing basic things like putting his shoes on the right feet. This is when Officer Lane becomes suspicious. He observes a strong odor of alcohol, and he classified it as strong. He told you that we walked around a couple of different areas. It wasn't just inside the car where the big bottle of alcohol was. It was also away from the car when he got Mr. White away from the car and started speaking with him. He saw and observed the red Solo cup on the ground next to the vehicle. And at this time, because he was not trained as a DUI certified officer, he called somebody who was. And why? Because he wanted to make sure the appropriate investigation was done because there was an accident. So what does he do? He calls Trooper Fernandez. Trooper Fernandez is a standardized field sobriety trained officer. He's worked the actual incident itself while Officer Lane worked the collision. What observations did Trooper Fernandez make? The strong odor of alcohol still, watery reddish colored eyes, the smell of alcohol coming from the defendant's breath, the fact that he had a slight sway when he was standing there. He said it multiple times, even on cross-examination. He stated, yeah, no, he was swaying. And if you pay attention to the video, you can see as he's standing there giving you the shot, there's a slight sway. He was polite and he was respectful to Mr. White. At no point did you hear him raise his voice. At no point did you ever see him screaming at him, threatening him, or anything like that. Why would he be nervous? I understand there's an accident or a collision that occurred. I understand there may be consumption of alcohol. But he was polite and respectful and gave him each opportunity and even asked him multiple times, are you okay? He then requested the field sobriety evaluations, medically cleared him. Defendant didn't complain of any head pain, any neck pain, any leg injuries. He stated he didn't wear any contact glasses at the time. He was also cleared by medical staff at the hospital prior to being taken to the jail. So not only did Trooper Fernandez medically clear him on the scene in the limited capacity he could, but he was also taken to Atlanta pretrial, Grady, and he was taken to the medical staff and cleared by medical staff, which he tells you is a requirement before they take somebody into custody when there's been an accident. Then he goes on to the HGN. The HGN can be very confusing. The horizontal gaze nystagmus, there's a lot of big words being thrown out, but the biggest thing is that, ladies and gentlemen, it is an involuntary reaction to the consumption of alcohol. The clues that he observed indicate that that person has had enough alcohol to cause that nystagmus, which is that involuntary jerking of the eyes. Think of it as a windshield wiper on a dry window. If it's raining outside and your windshield wipers are on, it goes smooth. But as soon as you stop the rain and your windshield wipers are still going, that's what the officer observes. It is incapable of being controlled by the person that it is happening to because it is a biological reaction to the action.
Objective facts, not an evidence.
He did state it was an involuntary jerking of the eyes, Your Honor.
I believe he did, Ms. Berry.
It is an involuntary jerking of the eyes caused by the consumption of. Now, we get to our walking turn. 5 out of 8 clues. And you can see here that he did each of these things multiple times. But as Trooper Fernandez explained on the scene, he didn't count every single one of them. That would be unfair to the defendant. If we had 18 different potential clues, and he counted it each and every time. But no, the standardized way that the people who came up with it required it to be done said you count the 8 times. There's one clue for each of these things he messes up on, even if he messes up multiple times. So he was given the benefit of the doubt from the beginning. He raises his arm. He steps off line. He misses heel to toe. He begins too soon. He has a difficult time following instructions. And Trooper Fernandez stated it multiple times. He didn't follow my instructions. I asked him to get there and you would see him get out of it. He would have to ask him to get back into that position. So ladies and gentlemen of the jury, I submit to you that the fact that Mr. White was incapable of following instructions is another sign that he was impaired.
What the fuck?
So I apologize. I have no clue what that was. All right, so now we get to our one leg stand, and our one leg stand, very similar. You see multiple clues of impairment. And this time there's 4 different clues that could be observed, and 3 out of those 4 clues were observed. And as you notice, Mr. White was unable to, as soon as he tried to raise his foot, he came down. Now I can understand if somebody was incapable of doing that, and you know, every once in a while they're coming down because it's a little bit hard for them. From the very get-go, his leg goes up and it goes right back down, and you just constantly see go up and down and up and down. And ladies and gentlemen, the more alcohol you consume, the more you're gonna sway, the more you're gonna lose your balance. It's difficult for you to be able to do that when you're impaired by alcohol. Now, I want to preface this by saying Mr. White has 0 burden of proof. He doesn't have to prove anything. However, based on what we see in the evidence, and based on I guess the theory of the case, the way the defense counsel says it happens. Well, we have some issues with their theory of the case. Mr. White never complained of pain. Even throughout the evaluations, he never stopped the evaluations to say, hey, I'm not feeling good. This doesn't hurt, that doesn't hurt. He was being evasive with his stories. But for defense counsel, he wasn't giggling. Nobody else was in his vehicle. He denied having any previous injuries. He didn't follow the instructions during the field sobriety evaluation and was given these instructions multiple times. For example, somebody is supposed to hold their head still, and Trooper Fernandez told him multiple times, hold your head still, keep your head still, look directly at my pen. But because of Mr. White's level of impairment, it made it more difficult for him to follow those instructions. They're claiming a lack of investigation. One thing that I noticed that the defense counsel did not bring up at one particular time in her entire closing was the fact that we, number one, have the odor of alcohol. Let's not forget that. We don't have just an accident that the defendant caused. We don't have just the 3 field sobriety evaluations that arguably don't look good at all for the defendant. But we also have the strong odor of alcohol emitting from his breath. We forget to discuss this. They want to say it was because he was a newbie officer. And the officer stated he didn't shy away from that. And our initial officer even said, I didn't want to do it because I wasn't as trained. I wasn't trained. And there's no requirement for us to go get a search warrant. So ladies and gentlemen of the jury, the defense's theory of the case has flaws. Again, we're not required to show that he's fall over drunk. DUI less safe doesn't even require us to show a less safe driving act, but yet we do have one. We have the fact that he caused a whole rear end collision with disabling damage to every vehicle. Again, let's not forget this. The reason why these field sobriety evaluations are performed is because they mimic essentially the exact same things that we're doing while we're driving. We're looking at multiple different things. So the fact that Officer or Trooper Lane is asking, Trooper Fernandez, excuse me, is asking the defendant to do all these things at one time. I need you to put your leg on the line. I need you to keep it there. I need you to listen to my instruction. I need you to not move until I say go. All these things are mimicking what we're doing when we drive every day. That's why they're important to us. That's why the state uses these and relies on these. Because these things mimic exactly what we do when we're in the car. And alcohol affects our body's ability to react quickly to these things that we have to consider. A prime example is a person who cannot stop in time and causes a rear-end accident. And ladies and gentlemen, I love to use an example. There's two examples I love to use. The defense's theory is that we believe he drank half the bottle. Personally, I don't believe that he would be standing if he drank half the bottle. But I'm saying that he probably drank enough of it to be a less safe driver. And what we will say is, I could be the greatest driver in the world. Best driver. I've NASCAR. I've never gotten a ticket in my life. So on a scale of 1 to 10, 1 being a terrible driver, I get in accidents every time I'm in the car. And 10 being I'm a great driver, I could be a 10. And if I have one drink, I move down and I become less safe than I was before when I was at a 10, prior to me consuming that alcohol. That is a great way to understand less safe. That is what it means to be less safe. Now, so why do we care about all these things? Again, driving requires a lot of things working together. We're not just looking at what we see, but what the impairment did to Mr. White's ability and his judgment when driving. It decreases the person's ability to react to situations quickly while driving. For example, paying attention, your motor functions, those are your standardized field sobriety evaluations. Paying attention should be inability to stay in lane, but inability to stop. Involuntary motor functions, HGN, things happening that we can't control. So, ladies and gentlemen, again, I just want to clear up what we saw during this trial. We saw a collision. We saw the scattered story of the defendant. We saw that he had balance issues. We all saw that he had the inability to follow instructions, the strong odor of alcohol, the slurred speech, the open container of alcohol sitting within arm's reach of the defendant, the red solo cup. Ladies and gentlemen, those things, all those observations point to the fact that he was a less safe driver. And what we don't see is any indication of injuries. And I want to discuss circumstantial versus direct evidence. While we didn't see any alcohol going into Mr. White's body, nobody observed him drinking. Just kind of think of it like if you go to a gas station and you know you got to put gas in your car because your needle's on low. And so you swipe your card, you put the nozzle in the tank, and you watch the numbers go up. They're going up, going up, going up, and a little bit more because gas is expensive right now. But you never saw the gas go into the vehicle, but you know based on all the other things around you and the fact that your gas needle is now on full and the numbers have stopped going up, you know that your tank is full. You put gas in your car. Very similar to the fact that we don't have to see Mr. White driving the vehicle when he's the one stepping out of the driver's seat. We don't have to see him consuming the alcohol when there's a strong odor of alcohol coming from his breath. That's what I want you to think of as direct and circumstantial evidence. You use all of that in the totality of circumstances to determine whether or not, or should I say that Mr. White was impaired to the extent that he was a less safe driver. Now, again, bringing it full circle, I asked a couple of people during jury selection, including our bartender or former bartender, what are the observations and the signs and the things that you see when you take keys away from somebody? And the reason I ask you those is because I want you to be looking for those things prior to coming into the case. I want you to say, well, we talked about that before. We talked about the slurred speech, the odor of alcohol, the unsteadiness, the swaying. We talked about those things. And that's exactly what we saw when we watched the video. What other witnesses saw. And we don't want you to abandon your common sense. Ladies and gentlemen of the jury, at the end of the day, the defendant was less efficient. The defendant was less skillful. He was less competent, less capable, less qualified, less proficient. Ladies and gentlemen of the jury, Mr. White was less safe that evening. And the only verdict that the evidence will come in is a verdict of guilty. Thank you.
All right. Just read you a few more things and then we'll get you guys back. You can have some lunch. All right. Your verdict should be a true and correct verdict based on your opinion of the evidence according to the law that is given to you in the charge. In deciding facts of the case, you must not be swayed by bias, prejudice, sympathy in favor of any party, Our system of law does not permit jurors to be governed by prejudice, sympathy, or public opinion. Both of the parties and the public expect that you will carefully and impartially consider all of the evidence in this case, while the law is stated by the court, and reach a just verdict regardless of the consequences. All persons stand equal before the law, and in courts of justice, all persons are to be dealt with as equals. You may use your common sense, common knowledge arising at your verdict. You are not required to put aside these elements of your reasoning ability during your deliberation. You are also permitted to draw from the facts in which you find to have been proven any reasonable inferences as justified in light of your common experiences. You're only concerned about guilt or innocence of the defendant. You're not to concern yourself with anything concerning punishment or sentencing. The form of the verdict that we're going to send back, if after considering your verdict during testimony, you, together with a charge of the court, you will find and believe beyond a reasonable doubt that the defendant in Fulton County did on or about May 29th, 2022, commit the offense of driving under the alcohol less safe, open container of alcohol as alleged in the accusation. You'll be authorized to find the defendant guilty. In the event that your form of the verdict will be, we, the defendant, find the defendant guilty on the particular counts. If you do not believe the defendant is guilty of any of the offenses, or if you have any reasonable doubt as to the guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict should read, we, the jury, find the defendant not guilty of the particular count. The verdict form should be self-explanatory. The verdict's in writing. Now, whenever your verdict's in the case, it must be unanimous. That is agreed by all of you. It must be in writing, dated, and signed by one of the jurors whom you select as a foreperson. It must be returned and published here in court. The court has no interest in the case. By no ruling or comment I may have made during the progress of the trial has the court intended to express any opinion upon the facts of the case, upon the credibility of witnesses, or upon the evidence or the guilt or innocence of the defendant. The court's interest in this matter is that the case be presented according to law and fairly, and that as honest, conscientious, and impartial jurors consider the case as the court has instructed you, and return a verdict that speaks to the truth as you find the truth of the case to be. My final instructions for you. One of your first duties in the jury room would be to select one of you as a foreperson to preside over the deliberations, to sign the verdict to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's view. Each of you decide the case for yourself, but you should do so only after discussion and consideration of the case with the other jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should never surrender honest convictions, opinions in order to be congenial or reach a verdict solely based on the opinions of other jurors. I'm going to release you to the jury room, but please don't begin deliberations until you receive the verdict form and the exhibits, which I will send you shortly. You may begin your deliberations. If you have any questions during your deliberations, write them down and please give them to Deputy Parker. If you wish to take a break during your deliberations, you can do so at any time. And please understand that you may deliberate only when all of you are together as a group in the jury room. And Deputy Parker, if you knock on the door, she'll hear it. She'll come get anything for you. Now, I need just our alternate, Mr. Nicholas Lofton, to hang back. And the rest of you can go to the jury room, and Mr. Lofton, you'll be able to go back and get your lunch after I finish speaking to you. He's not in trouble.
All right, for the jurors.
You did order lunch, right, Mr. Lofton? You ordered lunch, right? Okay. So, Mr. Lofton, since you were selected as an alternate, I'm going to allow you to leave so you can grab your lunch and you can leave. We appreciate your service as a juror. I'll remind you, as instructed, you still don't talk about the case with anybody. In the unlikely event that something happens with one of our jurors and they get sick and they have to leave, we'll call you. So, yeah. Do you have, we'll give you this piece of paper, give it to Deputy Park, you can write a number on there and we'll call you and let you know that you need to come back. And it's unlikely that anything will happen. So I'll call you at the end of the trial, and once they've reached a verdict, and let you know you're excused and you can talk about it. Okay, but you can go back once you write your phone number down and grab your lunch and enjoy the rest of your day and your $25. Yeah, so you can go back and grab your lunch and then you can leave, Mr. Lofton. Thank you so much and thank you for your jury service. All right, anything else from the state?
Nothing to say, Your Honor.
Ms. Berry?
No, Your Honor.
Okay, and you've already approved the verdict form, so we'll send the verdict form and the jury charges back with them and let them go. We'll call you when we've got a verdict. I know y'all probably want to go eat lunch, right? Or something.
Well, planning on staying around the courthouse.
Yeah,
Okay.
we'll be here.
Okay. Well, Ms. Clark has our number, so if we get a question or a verdict, we'll.
Sure.
a short phone call away.
Okay, sounds good. So the court will be in recess until we have a verdict. All right. All right, everyone could be seated. All right. Mr. Hollins, do you recognize these your jurors minus Mr. Lofton, the alternate?
Yes, that'd be correct, Your Honor.
And Ms. Berry, you recognize these your jurors minus Mr. Lofton,
Yes, Your
the
Honor.
alternate? All right, so we've got a verdict. Here says State of Georgia versus Joshua Elliott White. Case number. I need to be CR. DF, okay, DF 6398Y as in Yankee. The verdict form, count 1, DUI less safe. We, the jury, find the defendant guilty. Count 2, possession of open alcohol container. We, the jury, find the defendant guilty. Dated October 31st, 2024, and signed by the foreperson. Parker, if you'd like. Is anyone wanting to poll the jury?
The state is fine, Your Honor.
No, Your Honor.
Okay. All right, so people of the jury, thank you so much for your participation in the jury system. I know it was hard to take 2 days off and $25 a day, but we all appreciate it. Deputy Parker's going to take you right back here to the jury room, and I'll come back and speak with you. The prosecutor or the defense may want to speak with you after to ask you some questions. It's completely up to you what you want to do. If you want to answer their questions or not, it's completely up to you. So if you just say, I prefer not, they should leave you alone. But I'll be back in just a few minutes to chat with you and give you a couple of things, okay? All right, thank you.
All rise for the jurors.
All right, so do we have a pretrial officer here?
I've got a criminal
Oh,
history.
you do got the criminal history, okay. Ms. Barry, you want to hear the criminal history, of course, so we'll go ahead. What's the criminal history?
So he's got a previous, I think it was 2018 DUI that was reduced to a reckless driving. And that would be the only driving history that he has that's relevant to this particular matter, Your Honor.
All right. And what's the recommendation from the state?
State's recommending on count 1, 12 months to serve, 90 days in custody, credit for time served, balance probated, and alcohol and drug evaluation and treatment, 2 victim impact panels, 1 risk reduction course, a $1,500 fine, and 240 hours of community service and installation of an ignition interlock device, no alcohol or drugs while on probation. We would ask that it not go non-reporting after he completes, and he's on reporting for the entire balance of the 1 year. On the possession of open container, the state is recommending a $200 fine. As that one is not punishable by probation.
All right, and you said 2 panels, right?
2 panels, yes, ma'am.
Okay, Ms. Berry?
Yes, Your Honor. I mean, this is a first lifetime DUI conviction. I mean, I think the state's recommendation for 90 days, I mean, that would be completely inappropriate, considering what typically happens. I mean, I do want to point out that, yes, he did exercise his constitutional right to a trial by jury, but this is not a case where he got on the stand and said, no, I never drink, or we had some kind of crazy defense about, they switched seats in the car, or there was no antics here. He just held the state to their burden of proof. I guess I do want to point out a few things, and I would like to call some witnesses, Your Honor. want to call Mr. White's father to, in a minute, but I guess I'm getting ahead of myself. I mean, I do think certainly, I mean, I know that DUI is serious and that this was an accident. I mean, and he took accountability for the accident. You know, we conceded the open container. I mean, I do think that there was a limited investigation and this was a triable case. But of course, we fully accept the verdict of the jury. I do want to point out, you know, because we didn't put up any evidence and Mr. White didn't testify, but he did get medical care after this. And I have some of his medical records. He did have a documented concussion. I mean, there was, this was not, you know, throwing pasta at the wall to see what sticks. There was, you know, some issues going on here. I mean, obviously, there are statutory requirements associated with a DUI. I mean, it's required 12 months probation, and he's fine with, you know, he could be on reporting probation. We're not asking, we would not ask for that to terminate early. Certainly there's, you know, a minimum of 40 hours of community service. We could be happy to do 2 MAD victim impact panels. Certainly DUI school and alcohol and drug assessment with any recommended treatment. You know, Your Honor, he lives out of state now. Since this has happened, he's moved to Nashville. He lost his job. I mean, he's a professional. You'll hear more about that in a moment, but he's a professional. He lost his job over the summer. He's been job hunting. That was another reason why this was terrible timing for him, just in this coming up, because he was hoping to get a job, and, you know, it's a competitive job market and it's hard to have a DUI conviction. And he otherwise, you know, doesn't have a criminal history. So Your Honor, at this point in time, if I could call
Sure.
his father.
Absolutely.
Go up to the,
Y'all can both, you can stand at the
Should I
podium.
come
if
up
you
here,
like.
or-
Yes, sure. He can stand at just to make sure the court reporter can hear you.
the podium, or should I go up to the witness stand?
No, he can come up here if you want to both just stand at the podium or
Oh, okay.
I just want
That works.
to make sure that the court reporter can. Yeah, you can go ahead and swear him
Can
in.
you raise your right hand? Oh, you swear.
Do you swear affirm testimony should give before this court with the truth, the whole truth, and the truth, so help you God?
I do.
Please state and spell your legal name for the record.
Demetrius White, Demetrius. White, White.
And Mr. White, how do you know Joshua White?
That's my son.
And could you tell the court a little bit about him?
Sure. Josh is 26 years old. He has been an athlete all of his life. Graduated from Walton High School, where he was the first African-American quarterback. Went on to play football at Georgia Tech, where he graduated in 3 years. He is a member of the Omega Psi Phi fraternity. He is a consultant by trade. He has worked for both Capgemini and Deloitte. He is a certified project management professional. He has his PMP certification. As his father, obviously being here the past couple of days, I was disappointed in seeing a bottle of Casamigos in his car. Subsequent to this, however, I must say, if you look at his license, he was up to 280 pounds. He has been on a health journey for some time, and he has lost over 60 pounds. He hasn't had a drink in over 285 days. He's a current member of Alcoholics Anonymous. He hasn't had a drink. And so I feel confident as his dad. Number one, I want to see him get better, be a better man, do the right thing. That was never in question. Obviously, we did not want him to have a DUI on his record, as she said, but now I would just ask for him and myself to throw ourselves on at the court for grace for jail time. That boy don't know nothing about no jail. He grew up in the suburbs. He don't know nothing about no jail.
Thank you, Mr. White.
Thank you.
Ms. Berry, you have someone else?
Oh, sir, if you want to.
Yes.
Just, Mr. White, is there anything you want for the judge to know? No. No further witnesses, Your Honor. Again, I understand that 24 hours jail is the minimum required jail on a first lifetime offense. When I think about the goals of punishment, feel like, you've heard from his father. Mr. White's already going to suffer the collateral consequences, and now he has a DUI on his record. He's looking for a job. So this is certainly not something he takes lightly. I mean, that's why he, he hired a lawyer and wanted to fight the case because of the severity of the ramifications. This is not something that, drops off after first offender. This is with him, unless or until Georgia law has changed, this is going to be on his record for the rest of his life. And, is a big, scarlet letter. So, there's certainly professional ramifications for him. Your Honor, again, I would ask you just keep in consideration, I understand this is a trial and not a plea, but most oftentimes when someone is a first DUI offender, they're getting, limited to credit for time served in terms of jail. And I think he's someone who'd be very successful on probation and can get through his requirements very quickly. And again, he's been in AA. Certainly, we can provide documentation of that to probation. So we just ask that you keep all that in mind when considering sentence.
And just very briefly, I did want to explain the reason for the heightened on the first.
Sure.
The 90 days is not because of any type of trial tax or anything like that. State doesn't believe in that. But what we do believe in is the fact that if this was a situation where he was swerving on the road a little bit, the cop was behind him, saw him, he did a little bit rough on the evaluations, and that's what we have. That's one thing. We have a gentleman who was driving, had the bottle in his car. He caused an accident with two other vehicles. You saw the damage to the vehicles. All three of them had to be towed away. So, Your Honor, the state is not making the recommendation on this heightened jail sentence, or I guess jail request, just simply because we went to trial. But it's the simple fact that this is not a basic DUI. This is a DUI where he could have killed somebody. I mean, when they're on the interstate on Georgia 400, 85 northbound, everybody in this room who travels on the interstate knows how dangerous that interstate can be when you're traveling at high enough speeds. So that was the basis for the state's recommendation, not because we went to trial.
May I just
Sure,
stress
sure,
just
absolutely.
briefly?
Go ahead.
I mean, just with all due respect, I do think that any DUI is a DUI that could kill people. It's always dangerous to drive. That's why we have the standard of less safe. It could always kill someone if you drive when you're less safe than you would have been if you were not impaired by alcohol. And I just do want to point out, he says this is not a trial tax, but, at the beginning of the week, as of 2 days ago, if Mr. White was being offered, if he wanted a plea, a credit time served, no jail time plea offer. So I do think that to go from, a plea 2 days ago to having a trial, which again, he was on time for trial. There was no antics. There was no, no drama, to 90 days. It certainly does seem like a trial tax.
As we sat in your chambers in pretrial, the offer went up to 30 days, which was again rejected. So
Right.
it is a gradual increase.
Ms. Berry, what's your position on a limited permit? Is he asking for a limited permit?
He would ask for a limited permit, Your Honor.
Okay, all right. He's living in Tennessee?
Yes, Your Honor. He's still, because this was pending, he still has a Georgia license, and his father still has his permanent address is still in
Okay.
Georgia. But yes, he's trying to, he does live in Tennessee.
Are you employed now, sir?
No.
No? Okay. So you're living with your dad, and your dad's kind of covering your expenses till you can, okay, all right. All right, so this will be my sentence. We'll do if somebody pays a fine, who's gonna pay the fine? Dad? You'll pay dad back,
Oh, yeah. Yeah, absolutely.
I'm assuming. Okay, so we'll do the $200 fine. If your dad pays it, you gotta pay him back, okay? If he wants it in sweat equity or cash, that's completely up to him. 12 months. 24 hours of serve, I'll give you credit for time served. The rest of it's probate, your balance is probated. Limited driving permit as long as he qualifies for that. And the 12 months of probation, you'll have to do 40 hours of community service, completion of DUI and drug use risk reduction program, 2 panels of the MAD Victim Impact Panel or similar. They probably have it in Tennessee. I'm assuming that's where you'll be doing this or similar. So you gotta do two of those. No drugs or alcohol, no drugs unless they're prescribed, no alcohol during probation. Drug and alcohol evaluation, and if there's any recommendations other than what you're doing, complete those. Let's see. And which position on non-reporting after, you obviously want non-reporting after he completes all that?
Yes, Your
He
Honor.
wants him to be reporting. I'm just trying to, because with probation here, he'll be reporting virtually, I'm assuming. Are they allowing that, Ms. Clark? Oh, okay. And it's like $35 a month for probation? 49? If you get all that done, we'll let you go to non-reporting, but you have to submit proof of all that, okay? Because all this is gonna do is put more expenses on your dad. But you have to submit proof of completion of all of those. You can have, I don't know what they'll do for random drug and alcohol screens, but they may send you somewhere up there. And I think that's it. I think I covered it.
The risk reduction course is required.
Yeah, it said the completion of DUI and drug use for addiction.
So there's the alcohol, I just want to make sure we're all clear. There's the alcohol, drug evaluation and treatment that's got to be done within 30 days. And then there's a risk reduction course, which is essentially defensive driving.
Right,
And then there's the victim impact panels, which is like Mothers Against Drunk Driving, all that.
right. That's
Okay.
two of those. And
Okay.
And basically you'll see some of the signs say DUI school. That's what those are, sir. Okay. All right. So I think I've got all those, right, Ms. Clark?
Random screens, because he does not live in Georgia, he would have to do the random screens at his expense in Tennessee and when probation contacts him to do it.
And I know how to do that through Quest
Okay.
Lab, so I'll make sure
Okay, that's fine.
I put him in touch with that.
All right, that'll be fine. And the 40 hours of community service, you'll just have to find people there. Well, what they allow for community service if they don't know anybody, I'll know here, okay? You have any questions, sir?
No, Your Honor, thank
Yeah,
you
Ms.
so much.
Anything else, Ms. Clark?
They find out it's going to be the 1,500.
I
There's
just,
a statutory fine as well, yeah. I guess between 300 and 1,500 is
let's see, okay, instead of make it,
aggravated.
yeah, I guess make it 300 since he's not working.
Thank you, Your Honor.
Because he's got the other expenses of probation, random drug screens. Okay. I think I got everything. All right. Thank you, sir. Thank you, Mr. White, for your time. And
That concludes the state's business. May we be excused?
yes, sir. Thank you.
Thank you, Your Honor.
Thank you,
And
Judge Mann.
how's he going to report to probation? Are they going to come up here and meet him?
So I heard somebody at the door, I don't know if they couldn't come in.
That's right.
Okay, I'll put it in, not our probation.
Okay.
Oh, it was.
I'll step back here with George, hopefully.
Good morning.
Morning, Judge.
We have everyone present we need?
I believe so, Your Honor.
Okay. This is in the District Court of Rooks County, Kansas. Case number 15 DM 31. It is in the matter of the marriage of Dana Ganong and Richard Ganong. May I have an announcement of appearances, please?
Your Honor, Dana Ganong, now Dana Denning, is present and with counsel Todd Strammel Colby via Zoom.
May it please the court, the respondent Richard Ganong appears and with counsel Heather Fletcher, also both appearances by Zoom.
And Jennifer Harper appears on behalf of DCF, also by Zoom.
Okay. When we last got together on May 14th, the parties thought they would be able to put together an agreed upon order and submit it to the court. Where are we at, counsel?
Well, I'll go ahead and jump in. Your Honor, Ms. Fletcher put together an order and I think everything is agreed. The only issue that I believe is in regards to Mr. Ganong's current income. We need to add one more worksheet to that, given his new employment that began on April 22 of this year. The income that he has, Ms. Fletcher has provided several pay stubs. The main problem with that is his hours are going to vary. He believes that his hours in the winter are going to be a lot lower than what they are in the summer. And so anyway, that's the main issue as we see it, is what is the court going to establish his income at? Your Honor, our position is we could guess, we could speculate, but we just simply don't know. There's going to be a child that's going to drop off the worksheet next year who's going to age out June 30th. It just makes sense to me that we set his income today, but make that retroactive so that neither party is receiving too much or too little child support. So once we have a year's worth of income for Mr. Ganong, which will be in about May of next year, we can review his income, know exactly what his average annual income is, and then go ahead and set that amount and make it retroactive to May 1 of this year. So anyway, that's in a nutshell what I think our issue is today.
Ms. Fletcher.
Thank you, Your Honor. And Mr. Stramel is correct. I think we've come to an agreement on all of the other worksheets. I had sent him the my computations on the arrears calculation, and I don't remember, I sent that to him a couple months ago. So I think that we're in agreement on where we're at, and it comes down to Mr. Ganong's income for the 2024, and then of course going forward. Mr. Stramel is correct. He started, I believe it was in like the last week of April. I think it was April 22nd. So he had approximately 1 week of employment prior to the May 1st. And his hours do vary. When I looked at the pay stubs, he had one for 29.5 hours. He had another one for 35.5 hours. He had one for 40 hours plus 1 hour of overtime. And then his most recent one from August 18th was 33 hours. So they do vary. We had projected his income for 2024. We had projected it to be, I believe it was 29,200 just based on his hours that he's had so far. I would honestly estimate, Your Honor, that for 2024, it will fall somewhere between that $29,000 and $30,000 mark, just based on the history of his hours to thus point. I think there were 17, Mr. Stramel had sent me an email a little bit earlier, and I would agree with him that he's had, between the pay stubs that we've looked at, he's had about 17 weeks in of employment. And when I look at the calendar, I think there's about 18 weeks left in the year. So even if he stayed at his current number of hours for the year, if you add those together, it's going to put it in right in that ballpark of 30,000 for 2024. The problem is then that he hasn't been there an entire year through the winter season. And that's where we're struggling with what his hours are going to look like over the winter. My proposal was to, exchange information after they get their 2024 income. So we know what his income is specifically for 2024, do that in February. And we can recalculate if there's a up or down the 10% from where we land, we can certainly adjust. But I agree with Mr. Stramel also is that another child is going to drop off in June. So we're going to have to recalculate at that time because then there will no longer be the divided custody situation. And there will just be the one child. So I don't think it's fair to wait until June and then make this retroactive back to May 1st of 2024, because then we're going to be right back in a situation where we're either having an arrears or an overpayment. And I don't think either party would be served by that, Your Honor. I am, plus the fact that Mr. Ganung had not earned that income during the duration of the 2024 year. So I'm open to suggestions by the court on how to calculate this.
Ms. Harper.
Well, Your Honor, I haven't been really involved in any of the discussions between the parties. It was just this morning that I received copies of pay stubs. And I think it was just yesterday that Mr. Stramel reached out to me and provided me with any information on what they're doing regarding the child support worksheet. So I haven't had time to look at his pay stubs. I haven't had time to think of how it can be resolved. I do want a resolution, but I don't have any idea as to how we can do that with the court, because I haven't been kept in the loop.
Well, we have about 4 months of income at this job. And if the average is at 29,200, set it currently at the 29,200 income. Then you can monitor it, and if his income substantially goes up or down over the winter months, there may have to be a modification. But at least we'll be in the ballpark, and support will be fairly current other than any modification. If the parties agree, they can look back to May 1st after we get a full year and see if there was any modification. But we should get a current amount up and running.
And Your Honor, because Mr. Stramel had given me an average, I think it said 880.51. So when I took that, what he's made to date of the 14,000, and I can tell you exactly, 14,968.75. So 14,969. When I take that average and times it by 18 weeks left in the year, that would put him at $30,817.93 or $30,818. And that is just an estimate based on the average weekly.
Well, and Your Honor, if I can address that, in regards to Mr. Ganong's income, I'll just run through quickly the pay stubs that we've been provided. First of all, he's paid $25 an hour. He's paid weekly. He began his employment on April 22nd of this year. So he does have, for the pay stubs we've been provided, there's been 17 weeks. So the pay period ending 4/29/24 had 29.5 hours, and his gross income for that pay stub was $737.50. We received a pay stub ending May 6th of 24 with 18.5 hours with a gross income of $462.50. Pay period ending pay stub of May 20, 2024, 35.5 hours, $887.50 gross income. And then 2 other pay stubs, pay period ending May 27 of 24 with 41 hours, gross income of $1,037.50. And then the last pay stub was pay period ending 8/19/24, 33 hours with a gross income of $825. Your Honor, if you, and that last pay stub provided, the pay period ending 8/19/24 showed a gross year-to-date income of $14,968.75. That figure covers 17 weeks. So if you do the simple math on that, he's averaging $880.51 per pay stub or per week. You multiply that times 52, and he's on track at the current level to make $45,787. So if we set his income now and then just review it, if it changes, it makes sense to set it based on what he's actually making, which is a 45,787. And if his income drops, he can file to modify that. But yeah, we don't agree with the $29,000 and $30,000 figure. We think based on what he's making, which is what we've been provided so far, it should be $45,787 per month. And that worksheet would be effective May 1, since the income began in April.
Your Honor, we absolutely object to that because he has had literally 10 hours, he works in the pipeline in construction, and it is dependent upon the weather for a very large part of how much, they're going to be able to work. We are going into the winter. Since starting that job in April, he has earned a total of 10 hours in overtime since April. The largest majority of his pay stubs are under 40 hours a week. So we are not going to agree to a figure of $45,787. We would be setting him up for an issue. What I quoted, the $30,817.93, was literally off of what he's earned to date and just dividing that by the 17 and timesing it times 18 for the remainder of the year. And that's where that figure came from. He should not have to pay child support going back to May 1st of 2024 on wages that he didn't even earn.
Your Honor, that doesn't make any sense. The year-to-date income from April 22 is $14,968.75. He did that over 17 weeks. You divide that out, and it's $880 per pay stub, which is a $45,000 per year amount.
But Your Honor, Mr. Stramel is projecting that he's going to continue to work the same amount of hours throughout the winter months on the pipeline that he's working during the summer. And that just doesn't happen. And I think that that's reasonable and logical, that we understand that some employments, they don't work the same during different seasons. And I have no.
Ms. Fletcher, when you talk about a fall off, do you have any idea what the fall off is? There's got to be other people doing his job,
right,
to know what a yearly average is.
And I had inquired of him of that, Your Honor, and he may have more information, but my understanding is that he checked with, I don't know if it was his employer or other coworkers, but his information was that the hours are reduced considerably in the wintertime. So.
Well, is he going to obtain other employment then if he's not working very many hours in the winter?
I don't know what he's going to do. I don't know if it's an on-call situation where they, have to be available. I'm not that familiar with his concern. He may be able to answer those questions for you, Honor. I cannot.
Well, do you want to put him under oath and question him?
We can, Your Honor.
Mr. Ganong, would you raise your right hand, please? You solemnly swear and or affirm that you will tell the truth, the whole truth, and nothing but the truth, subject to penalties for perjury in the state of Kansas?
Yes.
Are you currently in the state of Kansas?
Yes.
Okay.
Mr. Ganong, can you explain to the court what your understanding is of your employment hours and how they may or may not vary?
Right now we go in at 7, usually off by 3 or 3:30. If we get rain days and stuff, we can't be out on the streets tracking mud and stuff. There's a lot of rain days we don't get to work. For the winter time, the guys that I work with said that it cuts down some. They didn't say what, but I don't intend on getting another job unless I absolutely have to. I have Ethan at home to have to look after too, and responsibilities there.
When the coworkers said that it cuts down some, did they give you any indication of what that means?
No, they didn't.
Okay.
And you don't have any guarantee on the number of hours per week, correct?
No, huh? I know in wintertime, if the ditch fills full of snow, that we can't cover over the snow, they said, so it's all up to Mother Nature.
That's all I have, Your Honor.
Okay. Mr. Stramel, do you have any questions of Mr. Ganong?
Just a couple, Your Honor. Mr. Ganong, as I understand your testimony, you lay pipe, correct?
Right, water mains.
And your income is going to vary simply depending on the weather, not necessarily the time of year, but the weather, whether that be rain or snow. Is that accurate?
Yes, and the jobs Water One are giving the company.
And I'm sorry, what'd you just say?
And the jobs that's coming in for Water One, as long as they continue to flow steady, then we should work steady outside of the weather.
Okay. Thank you. That's all I have.
Do you have any follow-up questions, Ms. Fletcher?
I don't, Your Honor.
And I did have a question.
Go ahead, Ms. Harper.
Did your coworkers give you any indication as to when it may slow down as a result of the weather?
No, I suppose it depends on the snow and stuff.
Okay. And would you be capable of obtaining other employment during the downtime?
Yeah, I could if I get something that works out with caring for Ethan too. My kids come first.
Mr. Ganong, do you receive paid vacation?
Not till after a year, and it ain't paid. We get vacation time, but not paid.
So it's unpaid vacation?
Right.
Okay. Okay, any questions based on my question, Mr. Stramel?
No, Your Honor.
Any questions based on my question, Ms. Fletcher?
No, Your Honor. The only other request I would have is that if we're going to exchange information or this is going to be recalculated, that both parties should be providing pay stubs, whether that's to, opposing counsel, Ms. Harper, so that we can get everyone on the same page.
Okay, well, the parties will need to continue to exchange the pay stubs. All we can do is look at what we believe his income is going to be. At this point, he's been averaging $880 a week. Take that times 50 weeks. He's got 2 weeks of unpaid vacation. That puts his income at $44,000. There will be a slowdown. So if we put that at 90%, that's $39,600. Now that may go up or down depending on the slowdown. And when we hit that year mark, next May 1st, obviously you have to look at the modification for one less child. Then you can look back and see what his actual income was for the year. And if we have to modify it, we'll modify it. But right now, the court finds his expected income to be $39,600. And we should do the child support based on that $39,600 yearly income.
And Your Honor, are we using on Miss Ganung's income, are we using her pay stub also?
Has her income changed?
Well, it's the income verification form shows that she makes 20 some dollars an hour, if I remember correctly.
Well, I think that she was getting credit for health insurance, and I don't think that's changed. I think we were not I think we're using a lower income amount for her, but not giving credit for the health insurance premium. So I mean, we can provide current income, but my understanding is that has not changed.
Yeah, if you could just provide me the pay stubs, Mr. Stramel, that'd be great. And then also to Ms. Harper so that we can see where we're at.
Do you have an agreed yearly income for Miss Denning?
Not for the current one, now that Mr. Ganung is also working, I don't believe. I was looking to see if I've got.
Well, no, I'm asking if we have her current yearly income.
We had her 2023, let me look here. I think we had her 2023 income, Your Honor, which is significantly, her W-2 is significantly different than what her employment verification was per hour. It looks like, oops. According to that sheet, she makes $20.06 an hour at 40 hours a week average.
Does she get paid vacation or unpaid, Mr. Stramel?
Your Honor, she said she has 15 days of paid vacation.
Okay.
And the last worksheet that would be effective September of 2023 has her at $27,477. That's on Ms. Fletcher's proposed agreed journal entry that we haven't finalized and filed simply because of this most current income child support worksheet.
Was that year to date or was that?
Your Honor, the 27,477 was her listed on that worksheet as her gross annual income. And that's what Ms. Fletcher drafted and I said was fine. And so if we need to provide current information on that for 2024, I'm happy to do that. Or she can simply testify, or I can proffer it, but I would need to visit with her. I didn't know her income was at issue today.
Well, on that yearly income, her hourly would be about 13 an hour. At 20 an hour, it'd be substantially higher than that.
Yeah, and Your Honor, she can testify if needed, but again, yes, her income is lower than what it would show on a pay stub, but on the other hand, she's also not receiving credit for the child support, or excuse me, for the health insurance that she's paying. And so that was the trade-off from a prior worksheet, that being she has the lower income, but she's also not getting credit for the health insurance premium that she's paying.
Is there a reason why we're not just using the income as it is and factoring in the insurance payment?
Because, Your Honor, that insurance, if the court remembers, that was optional insurance that she enrolled in. The children were covered under CanCare, and she chose to then enroll in, and it's very expensive. It's quite a bit a month. And so, and Mr. Stramel is correct that we agreed with that on the prior worksheets, the one that went into the 2023 in September of 2023, the one that's currently in place. But if going forward, we're going to be counting, you know, all of Mr. Ganung's income, then we also need to be going off of what her actual income is starting May 1st of 2024.
And do you know how much she's paying for the insurance, Mr. Stramel?
Your Honor, she pays $711 per month. And there's a backstory behind why she is carrying that insurance, which I believe has to do with the fact that Mr. Ganong was not carrying And so she had to pick up insurance.
Your Honor, I'd also like to state that state of Kansas always prefers that parents have their children on private insurance.
No, that's fine.
Because-
I'm not discounting that at all. And I'm not saying she shouldn't. She should have the children on the insurance. And if it's $7.11 a month, then give her that credit. But the income needs to be calculated appropriate as well.
Right. And Your Honor, the children were double covered. And she was not providing insurance for the child that resides with Mr. Ganung. She was only providing it on herself, her spouse, and I believe the other children, one of which who is not, I mean, he's not even residing in the home to my knowledge. So we need to get an accurate amount that she's actually paying for the child that resides with her, or the, you know, if she's covering the other child that resides with Mr. Ganung now, I don't know. But at the time, the last time we had this issue, she had not covered that child. She was just covering the one that was residing with her. But they are on CanCare and have been on CanCare for several years.
Well, the court would prefer using her income if she is paying an amount for the child, then that gets discounted off her income. That's part of the worksheet.
Okay.
But let's use the real numbers for hers, just as we're using the real numbers for him. And let's figure out what the child support should be.
And that's as of the May 1st, correct, Your Honor?
That's as of May 1st. Again, if his income substantially varies over the course of the year, we'll go back and look at it and see if we need to make a modification retroactive. Because we don't know how he's going to slow down, but I think we're going to be pretty close at 90% at that 39.6. And her HR ought to be able to tell her how much she's paying for the child's insurance. For whatever children she's covering, we'll know how much she's paying per month for that.
Yeah, we can provide that.
Yeah, and then just give her credit on the worksheet for what she's paying for the insurance.
And would point out that on February 29th, Ms. Fletcher filed an employment verification form, which includes how much is being paid for health insurance as well as the income.
Okay, so you've got that information.
It's in the court file, yes.
Okay.
I was looking at that form, Ms. Harper, and it says it covers the employee, spouse, and children. So we'll need to figure out how much for just that one child, or whichever children she's covering.
But we can provide that.
Okay,
Yeah.
great.
The numbers are what they are on that.
Right. And then you can run your worksheet.
Very good.
Okay, anything else?
Your Honor, there's also our request to issue an income withholding order. So far, no payments have been made since 2021. And that's continued since this case has started.
Have we calculated the arrearage?
Your Honor, and Mr. Strahm will jump in too if you feel here. Based upon the worksheets that Mr. Stramel and I had agreed to, that led up, or that went through the May 1st.
Hang on, we lost somebody. We lost.
Oh, we lost Mr. Ganung.
And I've got another hearing I need to jump on to.
Okay.
Judge, can I just?
What is the arrearage at this time?
As of the end of April, the current orders that are in place that the current worksheets that Mr. Stramel and I had agreed on, it's as of April 1st, the arrears was $1,578.75. as of May 1st, it would be 1,273.75 are the numbers that I had calculated based upon the worksheets that we had agreed to.
Okay, any objection to a income withholding order?
No, Your Honor.
Well, Your Honor, I don't know until we figure out what the calculation is as far
Right,
as like the
you've
current.
got the numbers you need to run your worksheet.
Right.
Once you get your current child support, then put an income withholding order in place. Let's get those payments rolling.
Right, yeah, whichever, yes, wherever it
Okay.
needs to go, income withholding order is fine.
Okay, anything further?
No,
Ms. Fletcher,
No, Your Honor.
Mr. Strangle,
No, Your Honor. Thank you.
Ms. Harper.
no, sir.
Okay. Could all run the numbers or have one of you run the numbers and you all share it and look at it, but we know her income, his income. Deduct out what she's paying for her child's insurance or the whatever children she's covering, what that insurance payment is, deduct that out. And then get the income set, the child support, and get a payment withdrawal in place. Okay,
Okay.
okay. Journal entry, Mr. Stramel.
Yeah, I'm happy to do the journal entry, or Heather, if you think it would be cleaner, we can add to the one that you've already drafted, but either way is fine.
Okay, we'll get it figured out.
Okay, do we need to set another hearing?
I don't believe so, Your Honor.
I don't.
Judge, I would prefer to set another hearing just because, I mean, think about how long we're having to go back due to it falling through the cracks before.
Didn't fall through the cracks, ma'am. My husband died, so there's been a little bit of a delay. Sorry.
I'm gonna jump off because I have to jump on another hearing, but you can set a status hearing in 90 days just to see where we're at. Okay?
Thank you, Judge.
You can schedule that with Jess. I'm gonna jump off and
All right, we're back on an emergency motion that I'm gonna try to discern here momentarily, so it was just handed to me. And it is somewhat of an emergency. I'm leaving when I finish the land lieutenant docket. This is an emergency record of the matter of People versus Logan Thomas. File number is 243131. Ms. Davis has filed a motion to cancel bond. Mr. Thomas is not here, and his attorney of record, Mr. Ross Truckee, is not here. And I don't know that they even know of the hearing. I set it about an hour and a half ago for 10:30, and I don't know that anyone knows. So Ms. Davis has filed a motion to cancel bond, indicating the defendant had been arrested on a serious charge of driving suspended, causing death. For a crash that occurred on December 2nd. Defendant was able to post bond on December 13th and release with conditions of no controlled substances and testing at the day reporting center. According to the motion, the defendant submitted a specimen at the day reporting center on December 16th. On December 19th, according to the motion, the lab report came back indicating the defendant was positive for methamphetamine. The defendant was released on the 13th. So presumably he would have not been able to use methamphetamine between December 2nd and December 13th. but his sample of the 16th, according to this, is positive for methamphetamine. This is interesting. This test came back, but they're still waiting for tests from the state police.
Nope. Actually, I'm sorry, maybe a little confusing the way it's written because the state police result came back yesterday afternoon as well. So it just happened to be that both lab results came in same day. So we do have the lab results from the date of the crash. And that is indicated in paragraph 6 of the bond motion.
All right. I didn't see that. It is believed that the defendant was under the influence of methamphetamine, amphetamine, fentanyl, and morphine at the time of operating the motor vehicle on 12/2.
So we do have the lab result back for that one with the.
All right, and it does confirm the presence of those substances?
Yes. The methamphetamine was in excess of 300 nanograms per milliliter.
All right, and the prosecution plans to amend the complaint.
Yes.
So the paragraph 13, defendant is risk to public due to his continued substance abuse and disregard of the law regarding operating motor vehicles safely. So she has filed a petition and affidavit for a bench warrant and an order forfeiting bond. There's no legal authority cited in here anywhere. I'm not sure I have the authority, absent any notice to the defendant or his counsel, to summarily revoke his bond. Do you have something that I could hang my hat on?
Sure. Your Honor, the court at any time is able to look at the pretrial release conditions and 6.106. And in this case, we do have a case that is very serious, being that there was the death of a child. And the conditional release is to ensure the appearance of the defendant and to reasonably ensure the safety of the public. And the court can order that pretrial release on the condition or any combination of conditions that the court determines are appropriate. The court did put conditional release terms on him, and he has not complied with those. So as far as revocation and appealing or modifying that release decision, we can file a motion to do so, and the court may decide to reverse that decision.
I set the bond myself.
Yes.
I believe we're here in open court, but I'm reluctant to do an ex parte revocation of bond and a bench warrant without any notice to the defendant or counsel. I'm going to set this for an order to show cause as to why the bond should not be revoked.
Your Honor, can I have just one moment? I have one other spot to check. 6.103 talks about the immediate revocation. 6H, the modification of a release decision prior to the arraignment on the information. So prior to the defendant's arraignment on the information, any court before which proceedings against the defendant are pending may, on the motion of a party or its own initiative, and on finding that there is a substantial reason for doing so, modify a prior release decision or reopen a prior custody hearing. And I guess we would state that this is a suitable reason to have this done. We do have laboratory testing, not only from the date of the incident, indicating that he is alleged to have drugs in his system at the time, which is going to increase the penalties that he may be facing, which makes it a consecutive potential for the driving while license suspended causing death and the OWI third or subsequent felony causing death. And he has prior possession of methamphetamine charges on the conviction. He has prior charges of analogs, which are what the other items were in his blood. either the fact that he had a period of what would be presumed forced sobriety while he was in jail, and then within 3 days of release on a very significant amount of bond, he's alleged to have tested positive, and they don't send it to the lab if you admit that you use. And I guess my concern is that DRC, the policy or procedure that they're using apparently is that they were just going to talk to him next week about it and then send over the violation. And in cases like this, where we have the very high potential for somebody to be seriously injured or killed, if I can't trust that the defendant is going to not use drugs, it's not much of a stretch to say we can't trust that he's not going to operate a motor vehicle. He is still working in St. Joseph County, a very short distance from where the victim's family resides. So there is a concern that he's continuing to come in and out of St. Joseph County and that he is still using illegal drugs. Thank you.
All right. Well, I certainly agree that I have the authority to modify a bond and conditional release, but I don't know as of whether, and I'm not going to do it, to do it ex parte without notice to the defendant or his counsel. It says you file a motion which presumes that there's notice to the other side. I certainly have the authority to modify the bond, but there's been no notice and no due process opportunity for the defendant to object. So the bench warrant would issue, he'd go into custody, and I guess then we'd have the hearing. I want to have the hearing before I issue the bench warrant or modify the bond. So
and I guess this was probably should have been marked as an ex parte, being that we believe there's a substantial risk of harm to delay these proceedings in order to give him that due process. And again, this isn't something where we have just hearsay or we think that he did something or it was a no contact and we think that maybe he had contact with somebody. This is a drug test that was lab confirmed from after he was released on bond. So again, certainly respect the court's decision. Just wanted to give the opportunity for the court to treat this as an ex parte, set it for a motion as soon as possible. But for the safety of the public, we believe that he is a risk, and based on his prior history, his failure to appear prior, the significant increase in the penalties that he's going to be facing with the additional charge, we would ask that the court issue an immediate bench warrant and bond forfeiture. Thank you.
all right. Thank you. He was charged with driving suspended with a death. That was what was known at the time, and I certainly concede, and I said this as we adjourned this matter. It takes time to get the autopsy report, to get the laboratory reports, get the accident investigation reports. It's very difficult to do vehicular homicide cases when the defendant's in custody, sometimes within 12 days of the arraignment. So the matter was adjourned. There was suspicion that there was methamphetamine perhaps used. Whether that's a fact or not, I don't know. But now, according to the plaintiff, that is confirmed. There's no indication he was driving. A very high percentage of our methamphetamine defendants with a condition of bond of no use of methamphetamine test positive for methamphetamine. Some of the old bond conditions did allow for an immediate arrest under a specific rule, and the Supreme Court said you have to provide more due process than that. We said just do an immediate bench warrant and then have a hearing later. Problem is, who is here next week?
Josh is here in person. I can be here virtually at any point. I will make myself available whenever the court is. Monday.
I won't be here Monday.
Or we could, I don't know what your honor's schedule is for the rest of the day.
I'm going to set it for Thursday, December 26th at 10:30. Defendant represented that he was going to retain Mr. Marcoux But there's a word in there, retain, which includes the payment of fees, and I would assume they would be significant for this type of case. He was advised, and Mr. Truckee was advised, that until further notice, he was still attorney of record. So I'm not even sure who his attorney is, but if and until Mr. Marcoux files an appearance, his attorney of record is still Mr. Truckee.
My understanding is that we received in our general email a substitution of attorney from Mr. Marcoux late yesterday afternoon.
All right, well, it hasn't made it to the court yet, but it sounds like it's on its way. Anyway, that's what I'm gonna do. I'm gonna set this for hearing. I'll be here. I don't want to dump this on Judge Pattison next Monday morning, plus getting notice to anybody between now and then. So set for emergency hearing Thursday, December 26th at 10:30. Might be more inclined to issue an immediate warrant if there was evidence the defendant was driving. But when he was here the last time, I believe he had a driver with him. All right, December 26th, you may appear by Zoom, or Mr. Robert may appear.
Thank you, Your Honor.
All right, we'll send out immediate notice. All right, thank you. Laura, would you come get this so we can get that notice out immediately? Send it to both Mr. Marcoux and Mr. Truckee. Thank you. All right, thank you. We're gonna switch gears back to the more mundane matters of
Thank you.
money damages. Thank you.
So on behalf of my clients, Judge, we're hoping you're having a good morning.
Oh, well, that's kind. I've been doing this for just a couple of weeks, over 10 years, and I've never heard such a heartfelt welcoming. Are they going to buy me a Christmas gift, or anybody taking up a collection?
We're considering that, Judge.
Yeah, I bet you were. Hey, how's your, was it your daughter that was going to school up in Oregon?
Yes.
What is she doing now?
She's still going to school there.
Really?
Yeah, we're leaving tomorrow to go up and see her. Gonna have her 21st birthday.
Oh my God. I know, recording in progress. She's no, you had a daughter that was my daughter's age that was going up there.
That was my son.
That was your son.
Right.
What's he doing now?
He's a captain in the U.S. Army.
Oh, wow. Really?
Yeah.
Well, that's good. Where's he stationed?
Hawaii.
Oh my God. Okay. And you and I think we're smart. Oh God, that's amazing. How long has he been in the Army?
About 10 years.
Wow. Did he see any action anywhere?
He's been deployed a few times, but not to a combat zone.
Oh, and that's so good. God.
I'm
So
here,
was
Judge. I'm here. Sorry to
Okay,
interrupt you guys. I
that's
just wanted
okay.
to let you know I'm here.
That's all right.
Thank you for waiting. I was making my coffee when I got the "we're ready" notification. I said I'll be right there.
Was it instant?
No, it was I have one of those like grinders where you put the beans in, and it's pretty fancy, but I got it at Costco.
Because if it was, oh God, it's so stupid. If it was instant, I would say you've got no grounds to.
You could still say that
I
because
guess I could. Well,
yeah.
Let's not get too complicated. It's already in the morning. All right. Okay, Mr. Loomis, would you say, did you waive a reading and stipulate to?
Yeah, Judge, we stipulate to a factual basis for all pleas of no contest. We'll waive a formal reading of the complaints and submit that the names of the defendants are correctly spelled.
All right, good job. Okay, let's go to Robert Nabicht, Nabicht, 11788, trespassing. What's the offer, city?
Offer is if we plead to trespass, I will recommend time served. There's one case, I believe. Unless
Okay.
there's other cases that I don't know about.
No, he's only had 29 prior cases. Yeah, okay, Mr. Nabich, are you there?
Yes,
All right, what's your plea to the trespassing charge?
not guilty.
Okay, let's put the bond at, you've got 29 RMC cases, you're no stranger, so I'm gonna make it a $250 bond. Normally I'd go an OR, but you've got too many cases. You make that $250 bond, young man, you go to the Reno Municipal Court, sign up for your pretrial conditions, which is obey all laws, no alcohol or drugs, and no trespassing at the GSR. That'll be the order. Thank you.
Judge, he does have a pending case over in Reno Justice Court, which is
Oh.
gross.
Oh, yeah,
Is it 250 bundable?
yeah. Why don't you enter a plea to it? I'll give you time served. Mr. Nabich, do you want to clear this matter up?
Your Honor, he left already.
Got it. Okay. Yeah, 250 bondable.
Okay, just
Yeah.
so the jail knows, his trial date is set for December 31st at 8 o'clock.
Good, thank you. Okay, let's go to Allison Werner, Werner, AKA Bonnie Mack. Are we there, Miss Mack? Werner?
Yeah, it's Bonnie Mack.
Okay, excuse me. What's the offer? Plead to it and
Yes, Your Honor, we have a trespass in this case as well. Just one case, I believe.
all right, Miss Mack, what's your plea to the trespassing at the Pepper Mill?
It's no contest.
All right. How long you been in jail?
I've been in jail for about 2 days.
All right, I'm giving you time served. Stay away from the Pepper Mill. Do you understand?
I hear you.
All right, thank you. All right, let's go to Emily Graves, Graves. And are you there, Miss Graves?
Yes, Your Honor.
All right, I take it your plea is not guilty?
Yes, sir.
Okay, you applied for, let me ask you, okay, your income is just over. If you're the only person you provide for?
Yes, but I do have 4 animals and my monthly expenses are quite high because of the situation I was in when I moved here.
All right, I'm gonna give you a legal defender then, young lady. Your pretrial conditions are you,
May I say something, Your Honor?
yeah, go ahead.
I was going to actually offer, because I do have severe PTSD and drinking has been causing episodes, to actually start going to AA and staying sober and providing proof of that to the court.
All right.
Your Honor, she only has, her pretrial risk assessment is a 5, so it's pretty low, just for your info.
All right, this is what we're gonna do, young lady. I'm gonna give you an OR release.
Okay.
Now, just listen to me.
Yes, sir.
You're gonna report upon release to the Reno Municipal Court. Your pretrial conditions are obey all laws, no drugs or alcohol. So my strong suggestion, you go back into jail if there's any booze detected. My strong suggestion is that you stay with AA. Do you understand me?
Yes, sir.
All right, Martha, trial date, legal defender.
I also requested no contact order.
Oh,
Sorry.
yeah, and also a no contact order on Aaron Jennings. No contact, don't call, don't write, don't text, don't email, don't get other people to call or text or email. Do you understand me?
Yes, sir.
All right. All right, trial date and legal defender, Martha.
Her trial date is set for December 19th at 1 o'clock. Eric Nickel is her legal defender.
All right. All right, good luck, Miss Graves. Stay sober. Okay, let's go to LC Corona, Corona 05562. Oh my God. Okay, what's the outcome? Plead to insurance and dump the rest? What do you want to do, Iris?
This one is, I would like a plea to the insurance and the license, if possible. If we can obtain the license, give time to cure, and then dismiss the rest.
Got it. Okay. All right, are you there, Miss Corona?
Yes, I'm here.
All right, what's your plea to no valid driver's license?
No content?
Okay, what's your plea to no insurance?
I do have proof of insurance.
You were insured on that date?
Oh, no, not on that date, but I currently do have insurance.
Okay, so what's your plea to not having it on that date?
No content?
Okay, do you admit failing to appear on June 16th of 2022?
I admit
Okay, I'm gonna give you time. How long you been in jail?
yesterday, but I do have to go home to my.
Let me explain it to you. It's gonna be time served on the failure to appear. The registered vehicle is dismissed. This is the way it's gonna work with the driver's license, young lady, is it's gonna be, you're gonna check in with the Reno Municipal Court when you get out of jail, which should be today. On the driving without a valid driver's license, I'm gonna give you 45 days to get a driver's license and present it to the court. Right now, you're fined at $195. If you get that license within 45 days, that charge is gonna be dismissed, or you owe $195. Do you
Okay.
understand?
Yes.
Okay, now on the insurance, it's gonna be a $743 fine. If you show up, if I'm gonna give you 45 days, and if you've got it, then that's no big deal. I'm gonna give you 45, you're gonna report upon release to the Reno Municipal Court. It's $743. If you can provide proof that you were insured afterwards, that fine's gonna go down to $195. Do you understand me?
Okay, yeah.
All right, that'll be the order. Go make sure you report upon release, or else a warrant goes out for your arrest. Get this thing wrapped up.
Okay.
Thank you.
Thank you.
You bet. Okay, Samantha Samara, Samara. I take it, plead to it.
That one, I believe I filed a domestic last night.
Yeah, I didn't. What'd you say?
I think I filed a domestic last night on that one.
You did.
Yeah.
All right. Okay, Miss Samara, you there?
Yes, I am, Your Honor.
Okay, I take it you're gonna plead not guilty to the domestic battery? Okay.
Yeah.
Did you apply for legal, is there a legal defender assigned, Martha?
Yes, Judge.
And did she qualify?
Yes, Judge.
Okay. All right, young lady, you're gonna get a legal defender. Your pretrial conditions are obey all laws, no drugs or alcohol. Stay away from 1851 Steamboat Parkway number.
That's my house though, my
All right,
apartment.
who's James Russell?
So
This is
James we've been together almost 9 years. I separated from him for 6 months when we first moved in. I did not put him on the lease because he was stealing my medications from me.
okay. This is the deal. I don't want to hear too much more. I don't want any contact with James Russell.
That's totally fine. I just wanted.
Okay, that's fine. Got it.
So,
Go back-
Your Honor.
Hold on a second. Hey, no contact with James Russell, no alcohol, no drugs, obey all laws. City on bail.
In this case, she only has a 4 for pretrial risk assessment, so I'm going to agree to recommend an OR, but there may be an issue with the residence, Your Honor, because it looks like the guy might be living there, and if he's not on the lease, then she's gonna have to do the like civil standby or something in order to facilitate whatever she needs to do, just so she's aware of that. And I'm sure Mr. Loomis has already talked to her about that, but in case he hasn't, then maybe she should contact him after court or something.
Judge, what I would like to say on Ms. Samara's behalf is she does have 4 children that are hers. They're all teenagers at this point, and she's advised that Mr. Russell is no longer living there. And I think that for continuity of the family, keeping the teenagers where they are is probably a better way to go. And so Mr. Russell looks like he's left.
Okay, all right. Okay, good. Young lady, I'm gonna give you an OR release.
Thank you, Your Honor.
Just listen to me. I'm gonna give you a legal defender. No alcohol, no drugs, no contact in any regard with James Russell. Don't contact him, don't have friends contact him, family contact him in any regard. Do you understand?
Yes, Your Honor.
All right, yeah, go ahead. What have you got to say?
I just want to tell you, I don't drink, I don't do drugs. I am prescribed prescription medications for
Right.
mental and severe chronic pain. But I just want to go back to my kids and go back to work, my job that I've been doing for 5 years.
Okay, you're gonna go back. You're gonna be fine. Just stay away from that guy.
Oh, I am now.
All right. Yeah, okay,
Trial date for pretrial conference is set for December 19th at 1 o'clock. Eric Nickel is her legal defender.
good luck, Samantha. Okay, let's go to Amin Asalati. Got two cases, two trespassings. Plead to one, dismiss the other.
That sounds good.
Okay, Miss Asalati, are you or whatever? Mr. Asalati, are you there?
Good morning, yes.
What's your plea to the trespassing at the Calneva on August 26th?
No contents?
Okay, the other charge is dismissed. How long you been in jail?
Since November the 5th.
Judge,
yeah,
he has, he's on probation with the DAS out of Reno Justice Court at this point.
Okay, so he's someone else. Okay. All right, this is what I'm gonna do, sir. The city want probation because there's two trespassers. Are we okay to do time served?
I think time served is okay with an admonition that we stay out of the named places, Your Honor.
Okay, all right. I'm gonna give you 5 days, Washoe County Jail. I'm giving you credit time served, so this will clear it up. But an admonition, young man, to don't step foot back on the Calneva and don't Calneva on both of them. Stay away from the Calneva. You understand?
Yes, sir.
All right, that'd be the order. Thank you.
Thank
All
you.
right, let's go to Jose Camarena. What have I got here?
You have, it looks like
It's a DUI, but it's got here Joey Gilbert's the attorney and he's unable to attend videos.
let me look it up in Odyssey really quickly because I think it might be like a case status hearing. Let me just double check.
Oh, I've got a tampering with the scram.
That would be a reason why he would be in custody.
All right.
I'm
What's
also gonna look it up just to, I don't think he's up for plea today, but I could be wrong, Mr. Loomis.
Judge, he reports that he is represented by Joey Gilbert. Mr. Gilbert said he can't make it. I don't have any authority to represent him if he's represented by Joey. So what I had recommended was perhaps we can just do a continuance.
Okay.
He
This
does
one
need
we're-
the interpreter.
Oh, he does. Okay, this is what
Yes.
we're gonna.
Señor, esto es lo que vamos a hacer.
All right, Mr. Camarena, we're going to continue this one day.
Señor,
No
vamos a
bail hold.
Ujú. Señor, vamos a aplazar esto un día. No va a tener fianza. Está retenido sin fianza.
He has a 30-day suspended sentence for 1 year, it looks like.
Tiene una sentencia suspendida de 30 días por un año, parece ser.
And actually, Your Honor, that was imposed on it was just imposed last month, October 30th of this year.
Se impuso el 30 de octubre de este año.
Okay, well, I don't want to do anything without his assigned counsel, so.
Of course. I just wanted to let you know what.
That's fine.
Y no quiere
Appreciate
hacer
it.
nada sin su abogado asignado. Por supuesto, yo solo le quería hacer saber.
So it's gonna be continued one day, no bail hold.
Se va a aplazar un día, señor. Está retenido sin fianza.
And
Entonces,
hopefully
no-
Mr. Gilbert shows up.
Entonces,
Thank you, young man.
Para que comparezca el señor Gilbert.
entonces no puedo salir de aquí de la cárcel.
I'm not going to be released then from jail.
No, your attorney's got to show up for you. Tell Mr.
No.
Gilbert to get his
Mhm.
backside in gear.
Tiene que comparecer su abogado, señor. Le tiene que decir al señor Gilbert que él tiene que comparecer.
I'm not sure how you to translate that, but good job.
She
All right, we'll
did a
see you
good job.
tomorrow, young man. Thank you.
Hasta mañana. Gracias. Thank you, Your Honor.
Thank you,
got
Miss
it, Carmen.
Interpreter.
Thank you.
All right, Daniel Day. Last name Lewis? No. Daniel Day. What time of? Daniel, what time of day? Okay.
Oh my God.
But, all right, I know. It's a sickness. What's the offer?
So we have a petty larceny. I would be requesting a plea to that, Your Honor. And then I don't have it would be a free to argue at this point.
All right, Mr. Day, do you admit failing to appear on July 17th of this year?
Yes, I do.
How long you been in jail?
Since yesterday.
Okay, I'll give you time served on that. What's your plea to the petty larceny?
No contest.
All right, city?
I would request a 30-day suspended sentence. We have a bit of a history. It's from last year. We have 2 cases last year, not of petty larceny. They were camping on public property. And then we have a 2021 case that's not really, it's a using smoking devices in prohibited areas. So not a huge history, but petty larceny in this case that occurred on, looks like June 20th of this year. And obey all laws. And I'm just looking at the place, asking for
It's
not a
Safeway.
Safeway, yes.
Okay. All right, Mr. Loomis.
Judge, Mr. Day is homeless and unemployed. I've advised him of the existence of community court, which he's interested in that. I think the typical suspended sentence with that is 8 hours of community service.
We would send him actually over to community court to be sentenced in community court.
That's it. Martha, is there room on the bus?
Yes, Judge, there is.
Okay, Mr. Day, it's gonna be no bail hold. You're gonna be referred over to community court, which will be tomorrow. They'll help you out with a lot of your issues in life. So that'll be the order. Good luck. Thank you. Okay, let's go to, good call from Mr. Loomis. Stephen Flood. You got 2 cases. No, he will get credit for all time served.
Do you want the offer?
Yeah, I've got here that there's a.
We do have a revocation hearing for
Yeah.
Central.
Yeah, I doubt, Mr. Flood, if you enter a plea to the trespassing, it's a potential that you get revoked on that other charge, but trespassing, I don't know if it rises to that occasion. So what's your plea to the trespassing?
I've already pled on the trespassing. No contest to Judge O'Neill.
Final motion from jail once OR. Oh, okay, city, go ahead. We've already, so what's your plea to the trespassing? No contest?
It's no contest, sir.
All right, city?
So my request would be if I could have a little bit more information. Mr. Loomis, did he plead yesterday or what's the deal?
It says that was on November 13th. I do have some additional information I think is relevant.
Okay.
And that is that Mr. Flood filed a kite with the court, advising the court that he's receiving services from the VA, and one of those services is what's called VAS, V-A-S, I believe, which is a way of subsidizing his having a place to live. And he reports that that's been his main problem is he's been homeless, but with the VA, he thinks he can get some type of residence with assistance from the VA. He is permanently disabled, and he is 64 years old. So what I would ask the court to consider is not to revoke and allow him to seek the services from the Veterans Administration.
I'm fine with that. You okay with that, Iris?
I am.
All right, Mr. Flood.
Hang on one second. We do have I'm looking at Odyssey right now just for more info. It looks like we have a community court sentencing hearing December 4th in this case. So I don't know if that changes anything, but I don't know if he wants to do community court still or if he wants to be sentenced over there, but I would agree to OR him unless you want to do what you just mentioned before.
Yeah, can you say that backwards? Okay, Mr. Flood, you want to go to community court?
Yes, I was hoping to
Excuse
get
me.
transferred there
I
tomorrow.
Go ahead, Donna. Is there room?
Community court stated that they can't help him.
Okay, so basically he's sent back here for sentencing.
All right, go ahead, Iris.
So, Mr. Loomis, I'm okay following what you recommended. You said to do time served, right, and let him seek the help of the Veterans Association?
Yes.
That's fine.
That's fine. Okay, sir, I'm gonna give you, you're not gonna get revoked on that charge for 6 months, no revocation. And on the most recent case of trespassing on November 2nd, I'm going to give you time served on that, give you an opportunity on your own accord to go over to the VA hospital. So you're getting out today, sir. Good luck and thank you for your service.
Thank you, sir.
You betcha.
Your
Okay,
Honor.
You're all done. Head back to the unit.
Congratulations on your son in Hawaii. 3 years there.
Yeah. Was he talking to me? I'm kidding. All right, Carlos Guillen Garcia.
Girlfriend? Sir, want to get the girlfriend?
Oh.
Did you say Guillen Garcia?
Yeah.
Okay.
Evaluation. Marshal review.
Looks like we have a disturbing of peace and arrest for violation of condition of suspended sentence, and
Yeah.
I would just to kind of hear what's going on from Mr. Loomis to figure out what I'm going to recommend.
Yeah, go ahead, Mr. Loomis. I've got here that we don't fail to appear for evaluation on August 21st, failed to appear for scheduled marshal review. Mr. Loomis?
Judge, I don't have a lot of information about Mr. Garcia, but he's prepared to admit those violations. We discussed the fact that he was supposed to get a substance abuse evaluation. And it seems like if that's what the court wanted, he should probably go ahead and get it. I don't know if he can do it out of custody or not, but the failures to appear make that look a little difficult, but I'd ask that he be given the opportunity to do the SAE out of custody.
Okay. You okay with that, Iris?
I am. I don't want him to be held for too long, but he does need to be supervised, because if he's not attending what he needs to attend, then the city would request some like heightened supervision.
All right. Okay, Mr. Guillen Garcia, are you there?
Sir?
All right. Do you admit failing to comply with the order of the court to get that evaluation?
Yes.
All right. How long you been in jail?
2 days.
Okay, I'm going to give you, that's a contempt. I'm going to give you credit time served on that. Now, what you're going to do, or else next time you go to jail for 30 days, I want you to report upon release to the Reno Municipal Court. They'll set you up in the Marshals Division. They'll set up an eval for you, okay? Don't screw this one up.
No, sir.
All right, that'll be the order. Thank you, sir. All right, let's go to Jay's.
Judge, give us
Yeah.
a minute. We have to set it up. The marshals will not set it up for
Oh,
him.
I'm sorry. Go ahead and set it up, Martha.
We're just going down the list now, right, Judge?
Yeah, we're going to continue on, Martha, and we'll just wait for Donna to get that.
I'm sorry, the evaluation is scheduled for November 25th at 1 o'clock.
All right, young man, report upon release, November 25th at 1 o'clock. Check in with the marshals, connect all the dots, get to that evaluation and move forward. Do you understand?
Sir, thank you.
You betcha. All right. Let's go to Jace Hines, Hinds. It's 07745. Okay. Mr. Hines, you there?
Good morning, sir.
Morning. Do you admit failing to comply with the order of the court to do your 8 hours of community service and go to community court?
I suppose so.
Okay. How long you been in jail?
Since October 14th, sir.
Oh, you're in jail on other things too, I take it.
Yeah, I gotta do a quick little justice court, man.
I got this. What I'm gonna do, I'm gonna give you for your contempt and the underlying conditions, I'm gonna give you 4 days Washoe County Jail, but credit time served. So that'll take care of the contempt, and that'll take care of the 8 hours that you were supposed to do in community service. So that's the order. This matter's cleared up. Thank you. Good luck.
Merry Christmas, man.
Yeah. Happy New Year. Justin Roach, ROACH 15004. What's the city's offer?
So this one is it's embezzlement less than 1,200. The complaint alleges that he stole $633 from Walmart. So at this time, I would be asking for a plea, and then it would be a free to argue. I don't know what Mr. Loomis's position is on that, but I'm kind of looking in to see if there's any restitution.
Yeah, I've got here that it's anyways. Mr. Roach, what's your plea to the embezzlement charge?
No contest.
All right, I've got here that it's Walmart on Kitsky, deployed 1 month, several occasions, about $1,000.
So the complaint says 6 something, the report has different information, and that's my question here is that I don't know exactly if he what amount exactly he owes. So maybe we could do an out of custody sentencing for him and
That's
then
fine.
do the restitution due diligence.
I think what happened was that Walmart actually came up with the 633. Mr. Roach had an estimate, couldn't remember exactly, and so he came up with an estimate of around 1,000. But
Okay.
Walmart's got it figured at 633.
Okay, we can go forward then. Go ahead, Iris.
So I would recommend a 30-day suspended sentence for 1 year, stay out of Walmart, obey all laws, and pay the restitution to Walmart of $633.
Your thoughts, Keith?
I think that's a reasonable outcome, Judge. I would say he has a warrant out of Carson City that he's going to have to answer. It looks like a contempt of court from Carson City. He does.
Go ahead.
He doesn't have a wife or kids. He does have a roommate. They share a trailer and share the rent on that. He's raised in Reno, and he can continue to live at the trailer.
All right, Mr. Roach, just what we're gonna do. You there?
Yep.
All right, it's gonna be, I'm gonna give you 30 days, Washoe County Jail. That is suspended for 1 year. You're on probation for 1 year on this charge. It doesn't have anything to do with your Carson City matter.
Yeah.
You get out of jail, report upon release to the Reno Municipal Court. Your conditions are obey all laws and make restitution to Walmart at about $633 and no contact with the Walmart at 4855 Kitsky Lane. You understand?
Yes, Your Honor.
All right, good luck with the rest of your stuff.
If I could raise one issue.
Yeah.
I think on the date that he was arrested, some of the money was in his pocket and was recovered by Walmart at that point. I don't know how much that was.
I think that was
633.
Is it $156? Was that the amount? 'Cause
I'm not
that's
sure.
what I was kind of looking in through the report.
Yeah. I'm not sure.
That's kind of the whole issue. I'm trying to figure out exactly how much is owed, but
How much money do you have in your pocket, Mr. Roach?
Yesterday, I want to say that was the $156.
All right.
That sounds.
that would be $477 remaining.
Yeah, I was just trying to do my math on that. Okay, $477 in restitution. Stay away from Walmart and be a good boy. Good luck.
Thank you.
Yep. Okay, let's go to Carl Shatspansky. I take it it's going to be not guilty. Oh.
Good morning, Your Honor.
Morning. All right, Mr. Spaczynski. What is that?
Sir.
Polish?
Yes.
Yeah, okay. All right, I take it it's a not guilty
I have
plea.
this one, Donna.
Okay.
God, your prior was September of this year. Okay, so I take it not guilty?
Yes, Your Honor.
Okay, and did we, a legal defender's been granted? City on bail?
So in this matter, Your Honor, as you see, the prior was just recently. We also have a driving on suspended / revoked license for DUI. So I'm requesting $7,500 in bail based on the danger to the community.
Mr. Loomis?
Judge, Mr. Sospansky has been employed for the last 2 years at Tesla as a production associate. I've been told him that in light of the very recent past conviction that he thinks he can make the $2,500 bail if it's bondable, but he understands there may be some pretty stringent conditions placed upon him because of the danger of the community. So I would ask that you can make it $2,500 bondable with the conditions as you see appropriate.
All right, you know, Iris, I wouldn't disagree with you, but I imagine this was set on Saturday when everybody had an opportunity to look at it. So,
And I don't know, Your Honor, if we set bail already, then of course we would have to defer to that.
so I'm gonna, Mr. Shabansky, I'm gonna make it a $2,500 bondable. Now, you get out of jail, you make that bond, and you're gonna report upon release to the Reno Municipal Court. Conditions: obey all laws, no drugs or alcohol, and you will be fitted with a scram device, and you'll be on heightened heightened.
Enhanced
Yeah,
supervision.
there we go. Thank you.
Then they
Enhanced
can-
supervision. What's that?
Okay, never mind.
And you got a legal defender granted you. So next time around, young man, you get another DUI within a 7-year period of time from that first DUI, and you're gonna be looking at prison. So anyways, just to advise, go ahead, give a trial date and legal defender information, Donna or Martha.
Yes, Judge.
And while we're waiting for that, I do want to just verify that he was heard on Saturday because we're at Tuesday.
He wasn't arrested on this on the 17th. This happened on the 17th.
Oh,
So that would have been Sunday. So we actually,
Oh,
the bill
okay.
wasn't previously set, Your Honor. I don't know if that changes your.
It does. It changes my opinion. I thought you went to a bail hearing on Saturday. I'm gonna make it $5,000 bondable. You are going nowhere real quick, and the danger to the community is very apparent. So I'm gonna throw that in. Instead of 2,500, it's gonna be 5,000. Go ahead, trial date, legal defender, ladies.
His trial date is set for January 8th at 8 o'clock in the morning. Eric Nickel is his legal defender.
All right, good luck. Good luck, sir. Stay sober.
Thank you, Your Honor.
You bet. Okay, let's go to Devon Self, SELPH. It's 11394. Okay.
Hello, Your Honor.
Hello, what's your plea to the trespassing?
Guilty.
All right, time served okay with you too?
Yes.
Time served, young man, stay out of trouble.
Thank you.
All right, let's go to Alan Winters. 1 of 2. We've got the second. Oh my God.
This one I would request a plea on the insurance and I would dismiss the license.
Oh,
We
okay.
have a suspended license also on the, you're right, on the second case. So that one, so on the first case, 03203, I would dismiss all but the insurance. And then on 03204, I would request a plea to the license, give him time to cure that. And then of course he has the 2 failures to appear that he needs to talk to.
Are you going to amend the driving license charge?
I am,
Okay.
483.550.
So no valid then, huh?
Yes.
All right. Okay, sir, what's your plea to no insurance on the first case, 03203? What's your plea to no insurance?
No contest, sir.
All right, you admit failing to appear on March 19th of this year?
I do, sir.
I'm giving you time served on that. Now, before we even get any further on the insurance, the driver's license on that count, on that charge is dismissed. Did you get insurance afterwards?
Yes, sir, I did.
Yeah, okay, then this is the deal. When you get out of jail, you're gonna report upon release to Reno Municipal Court. Your fine is $743.
Okay.
Give me 40, listen to me, I'm gonna give you 45 days. Get your insurance for your car or else an operator's policy, bring that back into the court. If you do so within 45 days, your fine goes from 743 down to 195.
Okay.
All right. Now, on the other charge, you admit failing to appear on March 19th?
Yes, sir. I actually did try to file a motion to make a new court date, but it was a very busy day at work and
Don't worry about it. I'm giving you time served on that. What's your plea to the amended charge of no valid driver's license?
No contest.
All right, now this is what we're gonna do. Once again, it's gonna be $195 fine. I'm gonna give you 45 days to get your license. If you get your license in 45 days, you're gonna show it to the court and that fine's gonna be dismissed or else you owe 195. On both of these charges, you need to report upon release to the Reno Municipal Court to set up those conditions. Make sense?
Yes, sir.
All right, good luck. Thank you.
Thank you very much.
You betcha. Maria Deloach. We have a motion.
Do we have a, we have a no, a non-competent, right?
Yeah, there was none in May 31 of this year.
So that seems like we're okay. So I would move to dismiss without prejudice based on the finding of incompetency.
Okay.
Just barely within the 6 months, but
Yeah, okay. Jeffrey, okay, so granted. Jeffrey Solcz, Solczyk, I've got non-competent November 18th of this year.
that would be a motion to dismiss without prejudice based on the finding of incompetency.
Okay, so granted. Okay, jail, Eric Duvall, is this a first refusal? I'm gonna give it, bump it 1 day, no bail hold. And Desiree Lawrence, first day refusal, jail.
Yeah, first day.
Okay, let's bump it a day, no bail hold. Nicole Boykin, bump it a day, no bail hold. And on both of those charges, and oh, let's see, it's 11 after 9. Is there, can we get